Check, check 1, 2. Check, check 1, 2. Check 1, 2, 3. Mic check. Yeah, we're going to be at that table. special long version of the Vandy rape trial. We're going to be bringing you this coverage. We're on at least for 5 days through the end of Friday. If it goes longer than that, it'll really kind of depend on whether we generate any funding over the course of the broadcast to enable us to bring any additional coverage. We anticipate this case will be tried in 5 days. The Corey Beatty trial was tried in 4, with the jury returning sometime around 10 o'clock p.m. And if we go to verdict and if we go to deliberation prior to Friday, we're going to stay right here until the verdict is returned. With me is Austin Davis. Austin, welcome.
Fletcher, nice to be here.
Thank you for joining me. Austin Davis, for people that don't know, was a guy that was involved in some litigation with Corey Beatty's attorney Warwick Robinson, and he came into the trial at the first trial when I was the lead attorney for Brandon Vandenberg, and I had him removed from the courtroom because I was concerned about him impacting Warwick's trial performance, and I was also concerned that there might be some commentary the jury would hear. I know Austin much better now and realized I should have never had him removed, but he forgives me, and so he's joining me today. I think you forgive me.
Yeah.
All right. So he's joining me today. We're going to be bringing you the coverage right here on Charter Channel 194, or you may be watching us on YouTube. We have a live stream there. Follow me on Twitter at Long Version Show, because I tweet out the stream, the link to the stream. Also on Facebook at Fletcher Long, and I tweet out, I Facebook the stream. That way you can follow us. Now let's talk about what we think we're going to see today. They picked a jury last week. Jury selection went until 8:10 p.m. I believe it was reported Thursday evening. They began Wednesday morning. Many of the jurors got flummoxed and frustrated at the length that jury selection took. And the lead attorney for the defense team is a guy named Randy Reagan out of East Tennessee, Knoxville, Tennessee, and he promised the veneermen, now they're jurors because they've been sworn, he promised them that the trial would be more of the same. Austin, you think that's some foreshadowing as to the length of the cross-examinations that we're going to see in this trial, that it's going to be a long and arduous path? What are your thoughts on that?
I think it would be a week similar to what we just saw in the other trial.
Well, I know that doesn't bode well for everybody. I was the lead attorney in the first trial, and as an attorney, I was not a shotgun lawyer. I didn't throw a lot of things out in the hopes that something would stick. I was more of a laser technician trying to focus my defense into a neat theory that I thought a jury could, one, listen to, and to which they could pay attention, and that I thought would be somewhat palatable for them. That is not the style of Albert Perez from California. I worked with Albert in the first trial. He and I butted heads about strategy. He is someone that is going to really throw out every conceivable theory. And Austin, I think we're going to see him much more involved in the strategy employed by the defense team this time. Last time it was kind of my show. That case was tried to a mistrial owing to a juror that lied to get on the jury that remains unpunished, that cost the taxpayers of Davidson County some $150,000. His name was Todd Easter. But it's kind of the difference between a chainsaw and a surgeon's scalpel is the best way, I think, to describe the difference between my strategy and Albert Perez. I think this week you're going to see the chainsaw. I want to talk a little bit about the lawyers. The gavel's going to wrap at 9 o'clock, and I want to talk a little bit about the lawyers involved. Tom Thurman is the lead prosecutor. He is the most seasoned prosecutor in the Middle Tennessee area. He is famous. He is called the Thurminator. He is not called the Thurminator for no reason. He has had numerous books authored about him and trials that he has conducted. Also on that prosecution team is Roger Moore. Roger and I tried a good number of cases against each other, or as we used to say when I was in the profession, we used to call that trying cases with each other. but it's an adversarial trial process. We were on other sides, but
Single
Roger and
named.
I regularly saw each other in court. We generally made law and had a good time anytime we had a trial together. Roger is a very able and competent attorney. He used to be a professor of law at the University of Tennessee. Jan Norman is on this team. She appears to be well versed in the technical aspects of this trial. She is the one that will handle technical witnesses, I believe. She did in the first trial. She's well versed in the retrieval of computer data and all of the rigmarole and process that entails. On the defense side, Randy Reagan is a notable and quite skilled appellate attorney. What that means, and I'm sure he has ample experience trying lawsuits at the trial court level, but what that means is he's going to be preserving the record. I expect to see a lot of objections. I expect to see a lot of statements about the law and the way in which this attorney believes it's being violated in the court's rulings. And I really think that there will be a tremendous amount of fighting fist and wrist all the way down through the verdict. It's going to be courtroom drama without peer. Troy Bolin is from, I think he's from Maryville, Tennessee. I know he's from East Tennessee. He's a young guy. I don't think he's been practicing law somewhere in the 6 to 10 year range. He probably has a good amount of trial experience, and he seems to be a people person, someone that can present concepts. He's the guy that they're hoping will identify with this Memphis jury. We're going to talk about this jury in just a moment. And then you have Albert Perez and Gene Osco. I don't know if Judge Osco, who has entered an appearance, I don't know the extent to which he will participate in this trial. He did not participate in the first trial. Albert Perez is very much a notebook kind of guy. You will see numerous notebooks, trial books up on the defense table. He is someone that likes to have a lot of documentation around him as he engages in examination. He's very thorough, and he focuses on detail, and that's what you will see from him when he examines. And it'll be interesting to see, Austin, how much influence on the defense table he exerts. The most dominant member of the prosecution side, I don't know that there is one. I think those three work well together, Jan Norman and Roger Moore and Tom Thurman. Tom Thurman's the most famous of the prosecutors. He is the senior guy, and they probably will defer to him quite some bit. He's very good, is Tom Thurman. He's very good. Now, we've got a Memphis jury. I've blogged out about this. I gave y'all kind of a precursor as to what this would mean. And Memphis has two distinct congressional districts from which they pull jurors. They've got the 8th Congressional District, which is in the East Memphis, is more of the suburban, middle class, upper middle class to even wealthy population base, high average income in that area, and they're going to be conservative and much more likely to be government trusting, I would say. Much more likely to give credibility to the government and its proof over that of defense proof, for which they'll be somewhat naturally suspicious, because after all, it's being offered in defense of a guy against which there's evidence that is audio and video too. The 9th Congressional District in Memphis is your inner city Memphian. Many of those residents, they have a very high Democrat voter registration in the 9th Congressional District. You're a Memphian, Austin.
Memphis University.
Yeah, you went to MUS. Talk to us a little bit about the difference between these two congressional districts and how they will factor into the makeup of this jury.
Well, I think that we don't know yet who's on the jury, because we've just learned, I think, that there's 7 men and 5 women?
No, there's 9 women, 9 women and 5 men, and that is dispositive too, Austin, because we focus grouped going into the first trial the case. We showed some focus groups the video. We played the audio. We gave them kind of our defense theory. This case focus grouped very poorly in front of women. It focus grouped horribly in front of young women. It focus grouped, it seems to me that young males, athletes particularly, I don't know how many athletes are all in the jury. Athletes, it focused grouped well with them. They tended to get the defense, and the defense is going to be largely a cultural one. Okay, so we know that there, for instance, is a financial analyst, according to Stacy Barchanger, a Gannett newspaper, the Tennessean, wrote an article a few days ago. I blogged on it yesterday. There's a financial analyst. There's a small business account executive. There's a woman whose child had been murdered in Memphis. And there is someone who had a friend who had been raped or sexually assaulted. It sounded to me from Stacy Barchanger's article that the jury selection tended to be somewhat strong in favor of the government, but we don't know what the other 9 components are. The 5 jurors that were detailed in the article, if they have 14 like that, this deliberation might be pretty short. But we don't know who the other 9 jurors are. Now, the way they do this, for everybody who doesn't know, they have 14 jurors. They obviously, you can only take 12 back to deliberate. They will not tell them all during the trial who the 2 alternates will be. They won't know either. The court, at the end of the proof and at the end of the arguments, right before sending the jury back to deliberate, will pull at random 2 names out of a hat or a box or something, and those 2 names will be the alternates. They do that because they don't want people that are alternates to not pay attention to the proof, and then lo and behold end up on the jury and they haven't been paying attention and they really don't know what's been entered and they don't have any recollection as to what anyone's testimony was. So it's a sound theory for doing it the way in which they do it, but that's what we're going to see. So the answer to what kind of a jury do we have Lee Dreyer at the courthouse in Nashville reporting on behalf of the long version. Now, Lee is the host of the Conservative Law and Politics radio program on iHeartMedia AM 1510 in Nashville, and he will be calling us. We're not going to give out a phone number. We want you to tweet your questions to at Long Version Show, or you can send us questions on Facebook if you want to send them to the Long Version Facebook page. We're going to be monitoring those social media outlets. We don't have a call screener, and we don't want to take a chance of getting a call out over the air that would be needlessly offensive or even vulgar. So we're not going to take that chance. But we do have phone lines here, and we will have correspondents that are able to get directly to us. They won't have to fight all the myriad calls, and they'll be able to get directly to us. And one of those correspondents is Lee Dreyer, and I am anxiously awaiting, Austin, I'm awaiting to see what he's going to tell us about this jury's racial composition. It's we know the gender composition is 9 females and 5 males. What is his impression of their presentation and affect? You know, you don't know, for instance, how many of them are middle class, how many of them are blue collar, how many of them are white collar. You don't know these things. We don't have the jury questionnaire information, so there's no way for us to know this. But you can look at the way in which they present, and you can arrive at some impressions. Now, my wife, Bebe Long, who's in studio, was my jury wife. Beautiful wife. Thank you. I did very well. She is a jury consultant, or she was when I practiced law. She was my jury consultant, and she is the blonde. If you remember the footage, she was the one that kept whispering into my ear during voir dire. So she was telling me people I needed to cut or questions I needed to ask.
This photo in the Tennessee.
Right. We had a great photo of her in the Tennessean,
you
absolutely.
brought the photo down, but she lifted it up.
Yeah, she lifted it up. I know I wasn't much at which to look, but I am looking thinner. Have you noticed that? Am I looking better?
Right.
Yeah, I've got the thank you Diet Doctors Clinic. They're one of my radio sponsors. Incidentally, I do have a radio show, and you can listen to me in the Clarksville area or even outside of by streaming it on what is that? TuneIn. They got a TuneIn app.
Yeah. Radio Free America, because you're the only person in the state of Tennessee that's reporting anything.
That's telling the truth. Well, it's reporting a version of it that is
I was gonna say,
somewhat government sanctioned.
You're a pro in all. You're a pro in all this, but I'm a guy that listened to Nick Breeze when I was watching the Channel 5 coverage.
Oh yeah, that's Nick Barris.
Barris, I'm
Yeah.
sorry. repeatedly, it tell people in Nashville, come on down to the courthouse. It's public.
Yeah.
It's open. You can come down here. And I was already in litigation down at the courthouse anyway. And so I happened to walk over, I think it was the day y'all were doing jury selection on a Friday afternoon, and I came in there and there were people, I've never been to a criminal trial, so you're a pro and you're used to you've had 200 trials, I think?
Oh, over 200.
Over
yeah.
200, so you're used to all this world, but I'm the guy that's sitting on the couch at home watching the news, getting a report, or I'm the guy sitting there that's watching, it on TV and listening to whatever they're telling me is happening. And now all of a sudden, over a year later, I'm sitting here beside a pro looking at the camera, and I don't know what I'm doing because this is all unscripted. And so my perspective of the judicial system is what the average person's perspective is, sitting out there in TV land watching what's going on here. And so I didn't know anything about it, and I went down there, and then when I went down there a couple of days later, I got banned at the door where all the media was, where all the cameras were set up, and where the media room was, and I wasn't allowed in the courtroom.
Well,
and
and I want to say this too, because the jury didn't go into sequester till Sunday evening.
Yeah.
That's pretty significant. That means this is a jury that knows about the Orlando club shooting where 50 died and 53 were injured, with worst mass shooting in the history of the country. This is a jury that knows about Christine Grimmie or Grimmie?
I think it's Grimmie.
Grimmie.
Christina.
She was a contestant on a reality show, talent show. I think it was The Voice, is it?
Yes.
And she was shot down in Orlando. This is a jury that knows about the Brock Turner sentence that was handed down by the court in the Stanford case. I'm going to ask that one of the assistants come here and take my phone. This is Lee Dreyer, probably calling from the courthouse, but we're going to need to give him a number for him to call into the studio because we're going to want to pot him on. But this is a jury that knows about Brock Turner and and they've seen the stories as outraged citizens, and rightfully, tweeted out a picture of Brock Turner next to Corey Beatty and made an apt note as to the stark difference between which they will be treated, one being a black man, one a white man, one of them being rather poor, the other somewhat affluent. You've heard the defense of affluenza.
If the jury has not obeyed what they were told to do, I guess
well, they probably were, but they weren't sequestered till Sunday night. So these stories were
they're able to see all that.
So let's talk a little bit about an effect I call the OJ impact. Okay, when OJ was acquitted, it really had a terrible impact on defendants getting fairly tried by juries, because you had juries that were much more cynical about defense tricks. You're not going to, you had a lot of jurors with the, you're not going to OJ me. I'm not, there were a lot of people in America who felt like that OJ should have been convicted. And they felt like that justice was cheated. And the renvoi effect, the renvoi principle of that, which is the snapping back, the resilient principle of that, was that people erred on the side of hang 'em high. Well, you've got Brock Turner, who receives a ridiculous, for the offense, ridiculous sentence, and you have to wonder, is that going to impact this jury? Are they gonna have a you're not gonna Brock Turner me type of impact in their deliberative processes? I think you have to wonder. I think that's a fair question. What do you think?
Yeah, I would think that they're going to wonder. What strikes me is that I had a hearing, an actual bench trial, after 7 post-trial Vanderbilt rape-related hearings, because nothing was done during the trial. My hearing started after the trial, and I had 7 of them. And my bench trial was with the Judge Cheryl Blackman on last Wednesday, and it was a 2-hour bench trial for contempt of court. And inside the ruling, it actually says that I was banned from the trial because I'd threatened an attorney and for the safety of all. And so this is based off of something else that had been done to me, where I was reported to the...
And I can say, as someone who was involved in that process, who actually was the one that had you banned, I did not ban you from that trial because I thought you were a danger to society. That is well, completely untrue.
All that's being used.
That wasn't even mentioned, and I was the one that argued it. So
well, and I had the police used on me, and that happened back in 2008 when this all stuff began that we haven't shared with the public, doesn't know yet. And so when that happened, what the basis was, is it was after the Virginia Tech shooting. And so then I was banned from a church in Nashville called Covenant Presbyterian Church in Green Hills, and they banned me and then sent police to my family, and Wark Robinson was involved in that. And so the point of that was to demonize me and make me into where I was a potential mass shooter, which we're seeing everywhere now. And so what you have right now in front of you, and if there are 314 million Americans out there, I would advise all of you to start tweeting and get this link out and let people start watching what's going on here, because the attorney that sat in the trial is sitting by somebody that's, by Nashville police, I guess, ruled to be a potential mass shooter.
Well, but that's not what you were.
Well, I know that.
But I'm saying people take those events and they try to relate them to other events, and that's the danger. And you've made a very good point. That's the danger in the Brock Turner story, the Stanford swimmer, the handsome white middle class to upper middle class athlete. What do you have on trial in the Vandy rape trial? You have a handsome Brandon Vandenberg, who went to Xavier Prep and the College of the Desert Junior College out in California, who is from a nice family, and he's handsome, and the visual similarities strike a chord with a jury that wasn't sequestered till Sunday night. I'm going to be interested to see how big that becomes as we go forward. How big is it going to be that they weren't sequestered till Sunday night? And how much impact, you had the young co-ed at Kansas who got on a national news story that she had been subjected to sexual assault at the University of Kansas, and that was covered up, and that it was a football player. Those type of cultural issues are going to come to bear. Okay, now Lee Dreyer has not quite reached the courtroom, which there's be no reason for him to get there early. He's on his way down there. He's called in to report, and when he gets a look, now Lee Dreyer is an attorney. He's the judge of City Court in Fairview, and he's the host of the Conservative Law and Politics show, the Conservative Law and Politics show, on AM 1510 in Nashville, which is WLAC. And so when he gets down there, his opinion, his impression of this jury and how they appear is going to be significant to me.
When you're talking about the jury, I as an average person, I actually was called for jury duty, and it was for sequestered jury to go to Chattanooga to do a murder trial over there where a policeman had been killed who was a 9/11 veteran, and he got killed, I think, on the 4th of July or something. I didn't know anything about it, but when I went through the jury process, and when they took me into the room and you went up there, it was all dark. I just remember there being armed people all in that room, and the accused was sitting there, and there was just one light down on top of where the witnesses went to sit. We went there and they asked us a lot of questions, and I was the next to last guy, and they didn't choose me for the jury. So I've had that experience a little bit.
You've been through that as a veneer man.
But I'll say this for the people that are out here: I still when you go in that room and you're in there, and even when I got in the courtroom that morning when I went and got to spend 2 hours in the courtroom, went to lunch and then got stopped out in the hallway, when you walk in that room, and most people out here watching never have been to a criminal trial in their life. They don't even want to go down to the courthouse. They don't want to have any involvement in anything down there unless they got a parking ticket or something. But when you go in there, and of course you live in this theater, you live inside of that, and you have to get up and go up there, and you've got people's lives on the line.
And people hate you
because
you have the audacity to present a defense.
And then there are 12 people, citizens. It's the highest duty in America other than going to military service, I believe, because you're called. I don't know, I still think Americans take that seriously, but you go in there, and so I pray that the citizens, with all the information that we've got in our society now, everything flooding to hit us, I pray they still can come in and feel the seriousness of being a person in that courtroom, listening to information, unless they're being managed in some way, or somebody's trying to fix an outcome or do, or in this case, in the case I got banned from, I actually had a special prosecutor assigned to me and was with him in court a few days ago. But juror number 9 didn't get a special prosecutor. I don't really understand how that goes down.
Now that's the guy for the don't recall the first trial. That verdict was vacated, which means for all intents and purposes, the fact that Vandenberg was found guilty the first time he really wasn't, because the verdict was vacated. The verdict was vacated because it turned out that a juror was a ringer. He had lied his way to get on the jury in order to influence that jury to arrive at a verdict that he predetermined to be the appropriate verdict. And so that's why this case is being retried. Now, to date, nothing has happened to this guy. This guy hasn't been charged. He hadn't been prosecuted. He perjured himself when he was put under oath to answer questions during voir dire, and nothing's happened to this guy. That is a question going into this trial, is why has no justice? Why no prosecution? Why are they running around prosecuting Austin Davis, and they're not prosecuting this
guy that literally...
Yeah. Now, your background, you're a pro-victim guy.
Yeah, I'm very...
That's your background. You're a very pro-victim guy. We have a victim in this case. She's a victim at least of Corey Beatty, because Corey Beatty has been convicted.
Yes.
She should not be called victim in this trial until such time as the jury returns a guilty verdict, because to call her a victim in front of the jury it denies a defendant the presumption that he's innocent of the charges. And that was not the ruling in the Beatty trial. It will be interesting to me to see how His Honor, Monty Watkins, who's a very bright guy, was a very good attorney. I think the world of him. He is as charismatic, cool, and together of a cat as one can be. He is. Now, it'll be interesting to see if when the witnesses that testify, if they are going to try to refer to the victim in this case as a victim. That will be interesting, and whether or not Judge Watkins will permit it. I can promise you this: Randy Reagan will be on his feet in a New York minute if they try to call her a victim. You're going to have to hand that to me because I can't read it. It's okay. You can come on camera and hand me things. That's perfectly okay.
I'm not a pro.
Fine. That's fine. Walk right into the frame and hand it to me, because it might be something I need to see. If that voice off camera is my former jury consultant, who knows more about sitting a jury than anybody in this area.
Yeah. This is how you know we're live.
This is
we're live.
Proof positive. This is the newsroom. Right here.
Yeah.
We want to really thank Sights and Sutton and Charter Channel 194 for this broadcast. This studio is, and we want to thank WSMV. Channel 4 in Nashville is permitting us to piggyback their stream. And that's how we're going to be bringing you the trial.
Maybe they'll open up and do some more coverage.
I mean, that is wonderful that they're doing that, and we really appreciate it. But this studio that we're in is fantastic. This is a fantastic facility where we are. And Steve Sawyer is a co-executive producer with me for this broadcast, and he's also the director and running the cameras. And I'm telling you, you're getting a nice tight shot. This is a quality broadcast. and it has all of the bells and whistles and graphics that you would expect. And I'm quite excited about being able to participate in what amounts to probably one of the more ambitious television undertakings in the history of Clarksville, Tennessee. And Clarksville is the 5th largest media market in the state of Tennessee. There's a lot of people that think Clarksville is a small town. It is not. It is a big city, and the skill that is being exhibited before their very eyes right now is has put the big city luster and ability of Clarksville on full display. And some of you out there may be wondering how your business can help sponsor this broadcast. You can contact Kay Sites at Sites and Sutton. And Steve, we got a number on her.
931.
Call 931 905 2616. Ask for Kay and say, hey, I want to get involved in what amounts to an epic broadcast, a one-of-a-kind undertaking, first time ever that this channel.
This is pure.
This is it,
from the
man.
grassroots.
This is the grassroots.
We may have 1 viewer. We may have 314 million when it's over.
You're on the ground floor, and isn't that exciting to be on the ground
floor?
I
want to say my wife is, she went to La Sorbonne. I don't know if I pronounced it correctly, and she's got
the Sorbonne.
She's very classy, way more than
Daisy.
Her husband.
No, Daisy's your daughter.
Yeah, Daisy's daughter, Catherine. So, but when I left to come up here last night, she said that, if you go stay or you're invited guests, this is a Southern thing for all those that may be watching that are outside of the South, that you have to take like a housewarming gift or you go there. So as I come to Clarksville, I've been up here a bunch on the radio show, Radio Free America is what I call it, beautiful place. And she said you have to take Fletcher something as a gift. So that is your my gift to you.
Shall I open it on air?
Oh yeah, go ahead. I think you'll enjoy
Steve?
it.
We ought to see what this is here.
So
I hope this isn't a bomb.
No, it's I may be.
Paying me back.
When the trooper came in that day in the radio station and stepped in the door, I thought I was getting handcuffed and taken out of the radio station.
Oh my goodness, looky here.
So there are 2 books
sir.
here.
Oh my goodness.
This
Shelby
is about a trial.
Foote, who is Follow Me Down, is a novel by Shelby Foote, the late Dr. Shelby Foote. He was not a doctor?
No.
That's incredible. One of the foremost.
He wasn't a college graduate.
Oh my goodness. And inscribed, may Christ richly bless you and your family. Best, Austin. Thank you so much.
It's got a trial on the outside.
It's all right. It's an old-fashioned courtroom.
Yes, and it's down. Took place down in Mississippi. It was a real trial. Shelby was working down there for, I think, Harding Carter's newspaper.
This courtroom, I'm going to show this on air.
Yeah.
This courtroom looks exactly like the courtroom in Ashland City, Tennessee, replete with chairs and everything.
Classic. That's a murder trial. It's a great book. Everybody ought to read it.
And Walker Percy's Love in the Ruins.
Well, you're a new Catholic, I believe. I think you.
I am.
And so that's a book by Walker Percy, was Shelby's friend. That book's dedicated to Shelby. And so anybody that doesn't has lost them because we're all just doing Twitter and social media. That's 2 books I'd highly recommend for your summer reading.
Well, that is very kind, Austin. Thank you very much.
Did
we know, Steve, how close we are to having any feed in the courtroom? Are they doing anything? All right, we're going to go to a break. When we come back, you're getting a special edition television long version of the Vandy Rape retrial. Well,
different
Do they have
medical
it somewhere?
histories, different drinking histories, different medicines they're on and not on. And I think specifically
I think
Okay.
they've killed it.
This is
Vanderbilt,
from the courtroom. This is obviously a break.
my opinion is
anybody
that
arguing,
he would
Steve,
not
or what are we saying?
be cognizant enough to be able to form
Well,
intent.
they would have the feed from the
Oh, I'll
court.
tell you what this is. I'll tell you exactly what
more
this
than
is.
first order
This is the
thinking.
expert that the defense
And that
wants
goes
to
back to that example,
introduce. And
that I
Judge
was
Watkins
talking about
has asked that they proffer
Maybe
what
the
his
driver
testimony
gave the
would
first
be
order
in order to
thinking,
determine
which
if he's
is,
going to admit it.
get my wallet and give the officer
None of those are
a
going to let
card.
them. They're all blocking this. They don't want this to
Now,
get out.
second order might be which card do I give him? And therefore the wrong card. But then you get to another step and it's, well, do I go for that blood alcohol or not? And each level of environmental cue or input that is coming in that's more difficult than the cognitive abilities just go down. So that's how someone who is highly intoxicated can appear to be functioning, talking, standing, and but in reality, if you push them with more difficult questions or more difficult situations, then the correctness of their answers and decisions are going to drop significantly.
And all of your opinions that you have expressed here today and expressed in your letter, those opinions are beyond a degree of medical certainty, is that correct?
I'm sorry?
Are based on a degree of medical certainty, is that correct? These are your
Yes,
opinions.
yes.
One second, please.
Reasonable degree of medical certainty is the standard that permits an expert to testify in Tennessee, and it makes his opinion admissible. That was Troy Boland offering what they purport to be their expert.
Medical certainty, a reasonable degree of medical certainty, is that correct?
Yes.
I don't have anything further on it. 30 seconds.
Okay, they're passing this witness now. Tom Thurman, the Thurminator, is going to cross-examine. And I expect this to be a vigorous cross-examination of an expert that the government very definitely does not want testifying.
Morning, Dr. Alexander.
Good morning.
When were you hired in this case?
April.
April
Yes, sir.
of 2016, I take it.
Yes.
You remember when in April?
Early to mid.
Okay. And I think this is your letters, I guess, slash report. Right?
Yes, sir. It is.
I'd like to make that exhibit to his testimony. And are you board certified in toxicology or neuropharmacology or any of those fields?
No, sir.
Okay. What specific training have you had in toxicology other than medical school?
Maybe some courses that I've taken, some continuing medical education, but I can't recall those from memory, and
Okay.
I can't say I've had any
So it's been a
in the
while.
last several years.
Okay. So, have you had any special training in determining blood alcohol, or do you just looked at the chart like anybody else could, or the wheel that some defense attorneys use to figure approximate blood alcohol?
The vast majority of times, the blood alcohol level is known to us. Sometimes it's not, and so we will
exhibit, is that the normal report you do in a case?
No, sir.
You normally list any testing you've done, you normally list all the information you've considered, any interviews you've done, all that type of information, don't you?
Yes, sir. But at that time, other than my conversations with Mr. Boland, that's all I had.
Okay. So you based your report basically on just what Mr. Boland told you?
Yes, and I'll clarify that by saying I asked Mr. Boland if Mr. Vandenberg had had any concussions
Okay.
and other medications, things like that. So,
But no documentation was given to you at all, and all it was just a conversation that you wrote down what was said?
no, I had some documentation.
What type of documentation? Since we haven't seen it, of course, what type of documentation is
It was an email of a series of questions that, and the responses to the questions. So,
Okay.
like,
it? So you relied specifically on an email. Do you have a copy of that email with you?
I probably do, but we might have to get on my computer to do that.
Okay. And fairly to say, I mean, you're a professional, you're a psychiatrist, you've been around a while testifying in court. That's not the normal evaluation you would do in making any finding, is it?
Not necessarily.
Okay.
If there were many times that during the course of a case that I might be involved in, I've been asked to give answers to questions early on. Then there have been times where I I actually meet with the individual, do testing, then do a full report based on all sorts of information that I've gathered by that point.
As a psychiatrist, excuse me, I didn't mean to cut you off.
And then sometimes I'm asked to reevaluate or information that I felt like I needed to do a complete report comes in, and then I might even see the person a second time and then do another report. So it's not unusual for things to be piecemeal sometimes.
But this wasn't really piecemeal, it was just an email and a conversation, right, that you relied on.
Yes, sir.
And as a psychiatrist, normally the most important tool you have is the interview with the client, is it not? Your forensic interview that you do most of the time?
That depends. If for example, I'm evaluating somebody that has an extensive medical background, there may be many different doctors that have seen that individual, and one of the things that it's important for me to do is evaluate the consistency and veracity or validity of what they're telling me. So if they say, well, I've never had an antidepressant, never seen a psychiatrist, never had problems with anxiety, and I look back at the family doctor records, and from 10 years prior all the way up until the time of the event that I'm evaluating, they've been on several different antidepressants and been on different medications. Also looking for consistency of reports to different medical providers. Somebody could fall, hit their head, and claim a myriad of neuropsychiatric symptoms, but when they go to the ER, maybe those records don't indicate some of the things that they're saying 2 years later, maybe much more severe symptoms 2 years later. So,
Have you ever given a professional opinion in court before based on an email?
no, sir. However, the question that I was asked, I had an adequate enough information to answer that question. It was basically to use a toxicologist's, or not a toxicologist, but what is well accepted in the field of toxicology, to take that equation, take the variables that I've been provided in the email. I also asked about height and weight and got that information. So I had all the information I needed to plug into the equation.
Okay. And is it not true that when dealing with criminal defendants that you must strongly suspect malingering?
Yes, sir.
Okay. And it's hard to determine malingering from an email, is it not?
From the amount of information I was given, absolutely. I didn't have enough information to determine malingering, just that one issue.
Were you able to review any prior statements Mr. Vanderbilt had given to the Vanderbilt authorities or the police department about his drinking that night?
No, sir. I had, at that point, I had very little information and
Okay.
very little personal knowledge of any of the cases.
And if he'd given prior inconsistent statements, would that given you concern as a psychiatrist?
Absolutely.
And you didn't review any video surveillance of his behavior during the night, did you?
I did later on.
But we're talking for this report that you're attempting to testify to.
No.
So you reviewed nothing else, no text messages, no witness interviews, nothing prior to writing your report, other than the email. Okay. And you familiar with the Journal of American Academy of Psychiatry and Law? You follow that journal?
That and several others,
Okay.
yes.
Are you familiar with a study that was done basically in the Netherlands, reported in 2004 about alcoholic blackout for criminally relevant behavior? Obviously you've probably read a lot of articles, you may not recall that.
I can't say that I've read that specific article.
That was a very lengthy study done. And would you agree with this statement made? Now these are two medical doctors, two PhDs, and a medical social worker that compiled this, but they said the consumption of large amounts of alcohol may induce so-called dissociative state. Dissociation defined as disruption of the normally integrated function of consciousness, memory, identity, and motor behavior that does not necessarily cloud one's consciousness. And they go on to say that although alcohol impairs short-term memory, which may interfere with storing information about ongoing behavior, remote memory remains intact. Thus, even during a blackout, a person could be perfectly able to retrieve rules of conduct and be aware of what he is about to do wrong.
Your Honor, I was just, if he's asking Dr. Alexander to give an opinion as to what he thinks about this particular report, then he needs to supply that journal to Mr. Alexander and let him review it in court if he's asking him.
Well, I can. I'm just asking if he would agree with those statements.
Your Honor, please, my objection is that asking someone if he agrees to just what Mr. Thurman read, he needs the report to determine whether he agrees with that.
I'll allow him to look at it.
He can look at it, that's fine.
What's going on here is they're attacking the basis of his opinion.
Well, I know that from just flipping through this, for me to really answer your question well, it would take about an hour for me to read through this, and because I don't know what blood levels they're talking about, I don't know what circumstances they're talking about, and there are so many different factors. You know, were these people on certain medicines, or have certain medical problems, or have brain problems? But in an overall sense, what you're saying that this says sounds appropriate,
Okay.
but with limitations.
Okay. Now, you mentioned intent a minute ago. About what type of intent are you talking about? A person is drunk.
It would depend on what they were posed with.
Right.
So, intent to make a decision about whether one should have a blood level taken or not.
Okay.
That's a higher order question. Takes deeper thought, considering a lot of different factors, considering information that maybe their friend told them, or information they heard on a commercial on the radio from an attorney, or lots of different things. And so anytime someone is confronted with whatever the situation is, and they have to make a decision, then they have to form some intent as to whether I'm going to do this or I'm not going to do this.
Okay. So you're talking about their intention to make a decision might be impaired, that their decision making might be impaired
Absolutely.
by alcohol.
Yes, and especially at levels that I talked about earlier.
And basically, I think that's what you said in the report, that there would be an impairment with a person if, in fact, that was a true blood alcohol. And it's hard to say that with any degree of certainty based on the limited information you had. Is that correct?
Well, the first part of your question, absolutely. And a good example of that is the illegal driving limit is above 0.08. And that came about because people have impaired thinking and coordination, decision making, and certainly the science indicates that when you're up in that 0.20 and above, regardless of which literature or research that you go to, it very consistently indicates that there are problems with the making judgments and interpreting environments, etc.
That's basically what you're saying in your report, that if it is true, this was the alcohol level of Mr. Vanderbilt based on the self-serving statement you were given, and then his reasoning, impulse control would have been diminished in some, or impaired in some way. Is that what you're saying?
Correct.
Okay.
Yes, sir.
That's all the question.
Basically, any opinion that he could have him state was not within a reasonable degree of medical certainty wouldn't be admissible. That's why he was asking the questions that way. This is Troy
Mr. Thurman spoke about
Rowland
an email, and I
to
believe your answer to
rehabilitate.
that question was that that email included everything that you needed to form your medical expert opinion. Is that correct?
Yes, sir.
And that those
As
questions,
far as the limited question or questions that were asked of me at that time.
and that's correct. Those were questions that you asked that you needed answers to consider and to quantify Mr. Vandenberg's blood alcohol content. Is that correct?
Yes, specifically what his weight was, and then my other question was whether he had had concussions, because those can negatively impact to a greater degree whatever the blood alcohol level is.
And you indicated you were hired 1st of April, middle of April, sometime in that neighborhood, right?
Correct.
Because I don't have any more question of Dr. Alexander, just brief argument, Judge.
All right. All right, you can step down.
Okay, that's going to conclude the proffer. The court should rule whether he's going to let this expert testify. The danger in not allowing him to testify is give them something that they can reverse on appeal. It seemed to me the safer course would be admit the expert and allow the government to make an excellent cross-examination about the information with which he was provided, on which his opinion is based. Again, this is a jury out proceeding the first morning of trial, and you're getting the long version of the Vanderbilt rape retrial. We're having some technical difficulties about a video provision that we were going to be piggybacking off WSMV, and the problem is really on their end. It's not anything over which we have any control.
But I do not think the state would agree to allow Dr. Alexander to testify, so I have tendered to the court a State v. Vaughn case, a 2008 case where the court was faced specifically with this question. This is a case where the public defender's office had given notice the week before trial, and the court actually pulled the funding, the indigent funding for an expert, and excluded, in essence, because it couldn't hire an expert, excluded that expert's testimony after notice had been given a week before trial. I'll point the court to the direction of page 14, in which Vaughn distinguished Hall. The trial court relied upon Hall when it excluded the expert testimony, and as we're well aware, we're not here talking about diminished capacity and or mental defect. We are simply here talking about voluntary intoxication. And at head note 23 on page 14, Judge, this is the Court of Appeals speaking. Furthermore, in our view, the trial court misinterpreted State v. Hall by concluding that it prescribed admission of the expert testimony proffered by the defendant. The Hall court explained that expert psychiatric testimony hearing only on personality types and character traits is not admissible, but that expert testimony showing that because of the mental disease or defect, the defendants lack the capacity to perform the mental state required to constitute the offenses for which he or she is being tried could be admissible, assuming that all other evidentiary requirements are satisfied. This holding, I'm talking about Hall, did not preclude the admission of expert psychiatric testimony bearing on the issue of voluntary intoxication as it affects an individual's ability to form the requisite mens rea to commit a crime. See Hall. Indeed, the trial court in Hall specifically ruled, and I'm moving on to the last paragraph, the last sentence. The trial court in Hall specifically ruled that the expert in that case would have been permitted to provide testimony and opinion as to the extent of the state of intoxication of the defendant at the time of the commission of the offense. And the Hall court expressed, the High Court expressed approval of the trial court's ruling. And it goes on to talk about voluntary intoxication and how it's not an affirmative defense, and how that voluntary intoxication, when used to negate the element of the offense. Judge, I point to this case because this case was reversed and remanded back because the trial court refused to allow expert testimony as it relates to voluntary intoxication. And it distinguished Hall specifically as it relates to voluntary intoxication. I would, a few things I want to point out when we're talking about time frames here. The minute that Dr. Sid Alexander was retained by our firm, we gave notice. Although I believe as a rebuttal witness I didn't have to give notice, but as case in chief we would have had to give notice. We gave that notice on April the 28th. Less than 10 days later, the state filed a motion to quash our notice of Dr. Sid Alexander. We had a hearing. This honorable court excluded Dr. Sid Alexander. It wasn't until last Tuesday, based upon our motion to reconsider, that this court agreed to allow Dr. Alexander to be pre-screened. Had 6 weeks when we gave notice that we gave notice. Again, the state was on notice in 2014. They have been on notice this entire time, and I'm not going to rehash what we've already hashed, but we gave them 6 weeks notice. At that point in time when we gave notice, even though they filed a motion to quash, they could have asked this court for mental health examination as it relates to serious mental disease or defects or diminished capacity. They did not do that then. They have not done that now. They didn't do that in 2014. And State v. Vaughn has distinguished Hall as it relates to voluntary intoxication. And we ask this honorable court, it's relevant, it is absolutely relevant, and State v. Vaughn demonstrates that it is relevant and that this testimony should be allowed. We respectfully request that this honorable court reconsider and allow the testimony of Dr. Sid Alexander.
All right.
Okay, this is going to be Tom Thurman who will be arguing for the government here.
Court, please. The court's order, final order, I think the third or fourth one, giving a deadline was December 1st of 2015 for all expert names and reports. The state got this letter/report on a Tuesday, 1 week before he left for Memphis for jury selection. The court had previously denied this expert testifying, and we had a hearing or had the motion to reconsider on a Monday before we start the trial on Wednesday by selecting the jury. Defense counsel totally ignored the orders of this court, totally ignored the rules of criminal procedure to gain a tactical advantage. And I've been in this case for 3 years. I think it's the most passionate I've felt about a motion in a long time. This is total trial by ambush. To allow this testimony denies the victim's constitutional right to a fair trial, denies the state of Tennessee its right to a fair trial. Their action in this case denied the state's ability to hire their own expert to either rebut the testimony of Dr. Alexander or to help us on cross-examination, and to think we could go out and hire an expert based on a name when we don't even know what he's going to say is a ridiculous argument. They denied us our right to have an evaluation done because we could not hire an expert. If you look at Rule 12.2, it's very serious about the defendant's failure to comply with the state's right to evaluation, and says that the testimony of their expert could be disallowed based on that alone. Now, obviously, they haven't refused to have him evaluated because of their tactical decision to wait till the last second. The state's deprived of their right to even have an expert to evaluate him. But they have circumvented the state's right to an evaluation, which that alone can allow the court to not allow this testimony. Can we have meaningful cross-examination? We just now got a CV today. I haven't had a chance to look at it. We had no information is relied on because evidently there's nothing but an email that we haven't seen yet. Now we know what test he did. Here we are starting our trial today. And also they denied the state's right to appeal. If they'd given notice on December 1st, we could have had this hearing in January. And if the court had granted Dr. Alexander to testify, which we think is against the case law in Tennessee, then the state would have at least a right to request a Rule 9 or take a Rule 10 and have that ruling done prior to the trial today. That's denied. I submit Dr. Alexander's testimony is not admissible under Tennessee law. You look at Hall and all the cases, Farrell, Faulkner, and the 2 cases I cited were more recent than the one they cited, Wilson and the Bonsi case, clearly say that the expert must say it's a lack of capacity, not speculate on impairment, not diminish capacity, which the courts have said over and over, at least our Supreme Court has. There's no such defense as diminished capacity. It's got to be a lack of capacity. And the case they cited, that was a case where Dr. Caruso said in his opinion the defendant could not have the capacity to premeditate. This doctor doesn't say that. Of course, he couldn't. He doesn't have enough information. He says, based on his report, and I think the testimony today, there would have been impairment, obviously, that we all know, and a lack of functioning. But that's not what the law requires. I think the law was clarified under Sergio Wilson, my case, and also the Bonsky case, where they addressed the very same issue and said the expert has to say it's a lack of capacity to form, in this particular case, a knowing intent, which was never brought up with this doctor. He never gave an opinion on anything saying that he lacked the capacity to form a knowing intent. Also, your court looks, there's another issue, is this necessary to substantially assist jurors? And they were voir dired extensively on just what this doctor said. Yes, your functioning would be impaired. Yes, your thought process would be impaired. Your decision making may be impaired. But all the jurors said, yeah, everybody knows that. They all agreed. They voir dired the jury on this exact same, what this doctor's trying to testify. It's not necessary to substantially assist the jury. The Vaughn case, they testified, even though Dr. Caruso said he lacked the capacity to form. It was a PCP case, which not every juror knows how PCP would affect a person. But I think every juror in voir dire explained they understand how alcohol may affect your decision making, but that's not a defense. The defense is a total lack of capacity. Being able to have a knowing intent, which basically is an awareness statute, that you're aware of the facts or the circumstances around you. And is this, the third thing, is this based on reliable information? Can you really, when this doctor has not looked at a single witness statement, has not viewed anything, all he's gotten is an email on self-serving statement from Mr. Vandenberg, who the court has heard testimony about statements he gave the police. Think of Vanderbilt, which totally contradict what he told this doctor, evidently, or Mr. Boland told the doctor, whoever told the doctor. It's strictly self-report, and the doctor acknowledged that that would give me pause if there were different statements had been given by this person. So it's his previous unreliable testimony or statements given, I think, are crucial here, plus the lack of all the other factors a doctor could have considered in this, that I think this opinion, clearly based on an email, which the state has never seen, is not sufficient reliable information to allow an expert to testify. Since Your Honor has allowed this proffer, I don't think there's any issue in ineffective assistance to counsel, since I think clearly this expert had been hired on time. It would still be inadmissible under state law, Tennessee. There's been argument about rebuttal. This would be a rebuttal witness, and he says they don't have to give notice. Well, he cited no case that I've seen. We filed a notice of authority with the court today discussing this. Obviously, a mental state is an issue in every case except where there's strict liability, and you would be able to say everything's rebuttal. There wouldn't need to be Rule 16, Rule 12. There wouldn't need to be all the case law excluding experts, because everybody would just be a rebuttal. Take an alibi witness. His theory is if the state calls in two guys and say, yeah, I saw him rob the liquor store, then they could put on an alibi witness and rebuttal. And that's not the law, and it's not the law in the state. If you look at Nice versus State and State versus Green, two cases that I provided for the court on page 6, and Bonsky, even the other case we've already previously cited for the case on page 27, it defines rebuttal evidence in Tennessee. Any competent evidence which explains or is indirect reply to or a contradiction of material evidence introduced by the accused or which is brought out on his cross-examination. So this is not rebuttal evidence, Your Honor, please. There's no such thing as rebuttal evidence for the defense. It's only SIR rebuttal, or they would rebut the state's rebuttal. And the purpose of that is because the state has no way to know what their defense is going to be. So the right to put on the defense we talked about, clearly Chambers versus the U.S., a U.S. Supreme Court case cited in a Mays case, the right to present a defense is not without limits. The Supreme Court has observed that the accused, as required by the state, must comply with established rules of procedure and evidence. And it clearly has not been done in this case, Your Honor, please. To allow this testimony is fundamentally unfair, and it clearly does not promote the fairness in the administration of justice in this case, which has been pending for now almost 3 years. And here we are the day of trial arguing about an expert. It's just not admissible under the law.
Okay, the proponent of the motion gets the last word, so this is going to be Troy Boland to make a last plea to the court to allow this expert to testify.
Maybe the rub is that the state tends to believe that we're talking about an affirmative defense, that we're talking about the same measures as an alibi or an insanity defense. That is not the case here. And I point the court to page 15 of the Vaughn case, and it's very clear in the 2 paragraphs to the left of the conclusion. Consequently, we conclude that expert testimony bearing on the issue of whether the defendant was intoxicated was relevant and properly admissible under Hall. The 6th Amendment and the Due Process Clause of the 14th Amendment to the United States Constitution clearly guarantees a criminal defendant the right to present a defense. It is relevant. Dr. Sid Alexander will testify as to the intoxication of Mr. Vanderbilt. Whether the jury knows about intoxication and brings their own life experiences into the courtroom is one thing, and I point again to that same paragraph under consequently. The questions of whether the defendant in this case, same paragraph beginning with consequentially, in this case was under the influence of PCP at the time of the offense, and if so, whether his intoxication had any bearing on his ability to premeditate and form the intent to kill, were questions appropriate for the jury's consideration. This is appropriate for the jury's consideration. And Judge, as it relates to rebuttal, the state, Mr. Thurman, keeps saying we have provided no authority. Our response to their motion to quash is littered with authority when it talks about rebuttal evidence. I'm sitting here looking at a case that I cite, State v. Husky, and it clearly cites, and this is in our response, it depends on whether the defendant intends to introduce or call a particular witness at trial. State v. Husky, 1998 Knoxville case. I can go on. I lay it out very handsomely. State v. Harrison, that's in our response. So for the state to suggest we haven't cited authority, we have cited authority as it relates to rebuttal evidence. If a witness were to get on that stand and say, Mr. Vandenberg seemed fine to me, wasn't acting out of the ordinary, wasn't stumbling, then we cannot be prohibited from rebutting that testimony to any degree, whether it come in the form of lay testimony or whether it come in the form of expert testimony. We can rebut that testimony. We respectfully request that this court allow Dr. Alexander. You know, there's talk that Mr. Boland has threatened the court with this ineffective assistance of counsel. The reason that's important, and actually the Vaughn case talks about this, they missed a deadline, and the trial court extended the deadline because they knew what the ramifications for that may be. The reason that's important, the state's first argument is Mr. Boland missed a deadline, Mr. Perez missed a deadline, Mr. Reagan missed a deadline. We've not known about this. We didn't have an opportunity to evaluate the defendant. Since 2014, all they would have had to do when they first got served the notice was to file a request to have the defendant evaluated. If they didn't want to do it then, when we served notice out of an abundance of caution, if the state wasn't presumptuous that this court was going to quash our notice of expert, they could have filed then 6 weeks ago. So to suggest that, well, now we don't have time to do that, Judge, well, sure they've got time to do that. Out of the interest of justice, this court can take all kinds of measures to allow them the time and opportunity to do that. They never asked. They have never asked. They haven't asked today. They didn't ask 6 weeks ago when we gave them notice. They didn't ask 2 years ago when we gave them notice. And they talk about all this self-serving statement. Well, I would submit to the court that Dr. Furslow, who has been on their expert witness list since the first trial in this case, was given self-serving reports. He has not interviewed anybody in this case. Those reports were relied on by information provided by the District Attorney General's office to Dr. Furslow. It's a pot calling the kettle black. They give them information. He relied on that informing his report. Judge, we would ask that our motion to allow, or our notice not be quashed, that it be reconsidered, and Dr. Sid Alexander be allowed to testify in accordance with State v. Vaughn.
Okay, the court's going to rule on something here that's before excluded.
Dr. Alexander to come to present what he had with respect to the issue of intoxication and possible diminished capacity. And I listened to the testimony and reviewed a number of cases such as Neese, Bunsky, Hall, Wilson, and somewhat a review of Vaughn, as pointed out by the defense this morning. And the court thinks there are three things that are really important in this particular case. First and foremost, the state put forth the argument that it did not have a chance to have an expert to rebut Dr. Alexander, and that's pretty much true. Keeping in mind that, as pointed out by the defense, that the state did not provide an expert to evaluate Mr. Vandenberg, well, neither did the defense. Dr. Alexander did not do an evaluation, as far as I can tell, by the testimony presented today of Mr. Vandenberg. The second thing is that Dr. Alexander was admitted to testify, or allowed to testify, as an expert in psychiatry, but upon cross-examination, he did not demonstrate any particular expertise in the field of toxicology, which this court believes is extremely important. If you're going to testify about one's level of intoxication, you should have some specialized knowledge in toxicology. That was not demonstrated here. Thirdly, his conclusions and opinions were based upon information supplied by defense counsel, as admitted in the form of an email, and not based upon any scientific information or documented information or any particular evaluation that he had provided. As such, the court believes that the underlying facts indicate a lack of trustworthiness in this particular case. And taking all those factors into consideration, the court is of the opinion that Dr. Alexander's testimony should not be allowed. We're going to take about a 5-minute break before we get started.
All rise.
Okay, the court is going to recess for 5 minutes, and I think we'll go to air. But he has ruled Dr. Alexander again excluded. So he is excluded the purported defense
All right, there you have it. The beginning, I guess, technically the trial has not necessarily started. You can call.
I need him in here now. I need him in here right now. We just heard, and I apologize again for the technical difficulties that we're experiencing in streaming the Channel 4 feed of the trial. Again, it is a difficulty on WSMV's end. It's not on our end. There's really nothing. We are reliant upon them to get their stream active before we can do anything. What we just heard, and we're going to continue to bring you the trial in audio until such time as we can achieve video. But we just heard what is called a proffer or submission of proof on why the defense asked the court to reconsider its previous ruling that Dr. Alexander should not be allowed to testify. Now, the court ruled him excluded, and the question we have from somebody that has tweeted in, they wanted to know, is that a ruling which could get the case reversed on appeal? And it certainly could. I think many of the arguments for why Alexander should not have been permitted to testify really went to the weight the jury should ascribe to his opinion versus whether or not the jury should hear it. I think a safe rule of thumb, Austin, is with a defendant is you kind of want to let them present anything that doesn't violate like the rape shield statute. You kind of want them to be able to put on a monicum of proof so that they can argue that they've had a full defense, for in the event of conviction they can't blame it on any of the court's rulings. And this will be a ruling that the defendant will attack upon conviction. The defendant will say, well, you know, we had this expert that would have testified that he was intoxicated to the point of being unable to formulate an evil mind to commit an offense, which you heard them say mens rea, that's what that is, and the court prevented the jury from hearing the testimony. That will be an argument on appeal upon if Vandenberg's convicted and he the proof is fairly daunting, I would say, but that doesn't mean that he can't win. But I mean, it's fairly daunting. On his conviction, you're going to see that ruling revisited by the defense team. They're going to blame that ruling. I think the safer course, of course, I'm not the judge, but I think the safer course would have been, I'll admit his opinion, but you know, I'm going to give the state a full, broad latitude to attack what efficacy the jury should place on this opinion, if any. You know, Thurman could have gotten up there and said, well, you just talked to him and all his information was self-serving and you didn't analyze him and you didn't do any type of an evaluation and you just went off of an email. And you know, you could have brought all those things that would have discredited the opinion and made the jury less likely to believe it. I think that would have been the safer course. What are your thoughts?
Well, again, I'm a guy that's sitting out here on the couch watching people in the judicial system and the lawyers and all do things.
Right.
From my perspective, unless it's something really bad, for whatever reason, I don't really know what those things would be that you keep out. I think the average person would kind of like to want to know what it is that's on here, what's going on, so that somebody can come to a decision, because you want to know information, and there's too much, and like even what we're trying to do this morning, I mean, we're trying to have a trial and ride piggyback WSMV, can't get the feed, and you want to get information out to people that are sitting out here in the public. There's 6.5 million Tennesseans that have got kids from all over the country that are in here in the middle of an international trial.
Right.
And it would be nice. We held the Scopes trial. We've had Martin Luther King's trial. We've had trials in
Jimmy
Tennessee.
Hoffa's trial.
Jimmy Hoffa. And so you've got basically me, just a guy over here that's just an average citizen who got banned from a trial, sitting by a guy that's been in the theater and presented closing arguments and done things.
But is presently disbarred and in radio.
Well, you and I are the two outlaws in the world.
The outlaws.
We got the prosecutors, everybody's coming at us. And we're here and we're tell everybody, we'll at some point in time hopefully be able to get the actual video to you.
Well, I want to say this. I want to say that Tom Thurman argued a very thorough position for why that evidence should not come in. He said, first of all, we were shanghaied and ambushed with it. We didn't have it in enough time that we could have ordered him evaluated, and that's not fair.
Yeah.
You're denying the state of Tennessee a fair trial. He said, second of all, the information on which that he relied is not reliable. It's not the kind of information that would make his opinion something that is admissible. See, his opinion has to be within a reasonable degree of medical certainty to be admissible. And he argued, well, you know, it's really the information that he was given is not sufficiently reliable for him to formulate an admissible opinion. Then he said, you know, and another thing is it doesn't greatly assist the finder of fact. The finder of fact, when the jury was being voir dired, when they were Veneermen, they said that they were aware that large, copious amounts of alcohol would impact someone's decision-making process and ability to formulate the intent to commit an offense. So why is this expert testifying in the first place? What good is he doing? And then his fourth argument, and this is just Tom Thurmond being the old war horse he is, he kind of got Troy Brolin caught in what's called a malapropism. Troy kept calling it rebuttal proof. Well, technically, the defendant doesn't have a rebuttal case. The first case is called the government's case in chief. Then the defendant puts on what they call a case in chief. Then the government is permitted to rebut the reproof of the defendant. So actual rebuttal proof is offered by the government, and then to the extent the court permits, a defendant can come back in and offer rebuttal. So all of that is hyper technical, but you heard Tom Thurmond go into it, and he was taking a little jab at Troy. I think it's Bolin. I hope I'm saying his name right. He was taking a little jab at Troy Bolin. Yeah. He was making a jab at his. Of course, Troy has a lot of experience, but in comparison to Tom Thurmond, none of us have a lot. Nobody has a lot of experience in comparison.
Video as soon as the jury comes in.
Okay, video's going to be up, but thank you, my lovely assistant and wife and partner. So we will have video when the jury comes in. So we're
going.
Courtesy of WSMV, so thank
I
you.
wanted to go back to the jury. That's American citizens. If we want to move from public trials and juries, 12-man juries, if we want to move from that, I mean, you can always depart from that. The founders came over and they kind of liked the idea.
They liked it, yeah.
Okay, so what I'm
Back
saying
in their day, it was really 12 men. Now it's 12 men and women.
My grandfather was a dairy farmer in Natchez, Mississippi. He went to about 6th grade. I think he maybe had a 6th grade education. I trust him on a jury. I trust people out here on a jury to get on a jury and to be able to sit there as long as they don't come in prejudiced. I couldn't serve on this jury. When I heard the first radio broadcast, when it first was reported what had been done, I mean, what I was hearing on the radio when the story broke, people wanted to go downtown and like throw a rope off the bridge. And
you were one of those people.
And I was one of those people.
See, the court chatterers ought to eat you up.
Well,
Austin Davis is your man. He's your man. He agrees with you.
And you move to other things and you go back and forth. And I, of course, had my own interest or involvement, I guess, with a lot of the people that are in all this. And so I did my own investigating in my own ways and my own things. But you move to different places. But at the end of the day, Tennessee's got to be able to provide a fair trial. If it can do that, can it provide a fair trial and have a fair hearing and let information go?
Are we coming back in or? Okay. From time to time, you're going to hear voices from off screen. Do not concern yourself with that because we have people that are going to tell us when we're coming back in. Go ahead. We've got something else from off screen.
Well,
what do you got?
Found out from Kathy at Court Chatter that Albert Perret, the attorneys are screaming at each other right now.
Oh, I've experienced this, Kathy. Albert Perez is unhappy with the proffer of the information by Bolin and Reagan, and Perez is screaming at them. That's very helpful in mid-fight to have some infighting. I'm kidding. That's not helpful at all.
Albert Perez objected in the middle of Thurman's arguments, and Thurman, quite rightly, is upset.
Well, they have history.
Wait a minute. Are they fighting with each other?
Each other.
Okay, so the defense team has now started battling each other?
Yes, and Judge Watkins intervenes and is trying to stop their little spat.
Is he battling Thurman or battling?
No, they're fighting each other.
Inside their own...
Yeah, they're in there arguing with each other. I knew this was going to happen. You know, in the first trial, Albert and I had words
According to
during the trial.
over the term hostess program.
Is that what the fight is? Okay, now, hostess program, let me explain. In the first trial, it was a defense theory that the alleged victim, she's alleged in as far as the Vandenberg trial goes. I'm going to use that terminology because, I have a doctorate in jurisprudence. But she, the alleged victim, was the defense's theory that she was a member of a program, a hostess program that was sort of meant to show these guys a quote-unquote good time, and it was part of the defense theory. The government has persisted throughout that there is no such program. I don't know that it's that key of what they are called, how they are, how how they are referred, I don't know that it's as important as what Albert Perez is making it presently. I think you can make that point maybe more artfully, perhaps, than what the defendant is trying to do here. But it was an issue. You know, there was an issue the last time about that. But I did want to point out there's going to be some strident back and forth between the state of Tennessee's table and defense table over the course of this trial. There were times, and some of the stuff we're not going to get to see the good stuff. The good stuff is back in Judge Watkins' chambers. If I could pull the transcripts from the first trial, if you could hear some of the fighting that went on back there, I mean, there were times back there where Judge Watkins had to just about separate us. I remember one time in particular, Warwick Robinson and Tom Thurman got particularly animated with the other. And that's not a Warwick Robinson trait, really. And it was kind of off-putting and out of character for him. I find him to be a gentlemanly and somewhat reserved, but he lost his cool. You have those moments in a trial where, and there's oftentimes you come out of a trial. I tried 4 really huge cases with Roger Moore. Huge ones. I mean, wooded rapist cases. I never developed any hard feelings for Roger Moore as a result, nor do I believe he did of me. Roger and I consider him a friend. I think he feels the same of me. He has been quoted before as saying, although it's my every intuition not, I can't help but like Fletcher Long. I like him too. We're both St. Louis Cardinal fans, for one. So that kind of supersedes any bad blood which could exist. I will say that I admire Tom Thurman, as he shows me his Boston Red Sox bag.
Yeah, all you Boston Nation out there, Red Sox Nation will.
I admire Tom Thurman. I think he's a really good prosecutor, one of the best I've ever seen, and I like him. I do not believe that feeling is at all reciprocated, although we are civil when we talk with each other. Do we have more?
Well, apparently the issue started when the defense referred to Brandon Vandenberg by his first name, which I'm not sure what the...
You're not permitted to do that. All right, so an issue, I don't know. Steve, are they able to hear BB when she talks? They're getting her? Okay, all right. BB, who was my trusted trial consultant when I was a professional trial attorney and worked in this case as much or as hard as I.
And beautiful wife.
And a beautiful wife, said that one of the issues was the defendant being, the defense counsel referencing Mr. Vandenberg as Brandon. Now, that shouldn't happen. It violates the local rules of practice in Davidson County Circuit Courts, that it is a local rule that defense is to refer to the defendant as Mr. So-and-so. They're not supposed to personalize it. Reason being is that sympathy is not supposed to play a part in why a jury reaches a verdict. That's the same reason they're not allowed to give range of punishment.
In a further attempt for sympathy, Mr. Reagan also pointed out that Mr. Vandenberg's family is in the front row. Apparently his mother, father, and twin brothers and other family members are present in the courtroom. Thurman objected, and Watkins said that the family's attendance was irrelevant to the proceedings.
Okay, now what Kathy Russin, I think, is referencing there is what happened during voir dire. Yeah, okay, all right, this happened in voir dire. I read Stacy Barchanger's article on this. When we come back and the jury is brought in for opening statements, we will have video. We will be live and on air, and WSMV's feed is going to be remedied. Maybe what the issue was is that they didn't intend on airing this pre-jury portion. It may not be a technical difficulty on SMV's part at all. It may just be that they had no intention of airing anything prior to opening statements. We are now coming up on 10:15, and we haven't given an opening statement yet the first day of trial. So if that gives anybody an idea of how long this will go. Yeah, go ahead, Austin.
Well, the jury is just citizens. They're brought in and they're vetted in some way. Last time it looks like somebody got through the vetting process that maybe shouldn't have. But if you look at polls and you look at the mood of America right now, especially after the Stanford trial where they had 1 million signatures, they're trying to recall the judge. I mean, people out here, the average American, they're upset, and they don't. If you look at the polling, they don't trust the government very much. They don't trust they don't trust the media. They don't trust anybody hardly very much. I mean, they don't trust their elected representative. I mean, it's bad. It's the worst I've ever seen. I'm 6 years old. It is the worst I've ever seen in my life. And I just want to say, I trust the jury. I trust 12 of my fellow citizens to be able to go in there. As long as they're able to get in there and they've been vetted properly, I trust them to get in there and to be able to be able to sort through all of the competition that goes on in that room in heavy drama, because I've been in the courtroom, and just being in the courtroom, when you go in that room and that's going on in there and you're up there in the theater, for a person that isn't used to it, you feel it in the air.
It's oppressive.
It's electric in there.
And oppressive.
Yeah, and
when
oppressive.
When you're a trial attorney, it just bears down on you. It's like this force that's crushing you.
Yeah, and so I'm just saying, I trust my fellow American citizens that are out there, that they can go in there, and I've had juries where I didn't like what the verdict was when it was all over.
Well,
but that's the founding fathers decided to have a way that it was going to be done. They didn't like a secret tribunal somewhere, the king pulling in saying, take him out and execute him or whatever. They wanted to err on the side of even letting somebody go that was guilty if you couldn't prove they were guilty.
Right.
And so even a not guilty verdict doesn't actually vindicate the person and say that they didn't do something.
Yeah, there is no finding of innocence.
Yeah.
The two applicable verdicts are guilty or not guilty, and then there's a third verdict that's called hung jury, where they couldn't arrive at a consensus.
If we want to do it in the streets, if we want to go back to the street method or the things that we all familiar with in the South, then we can do that. But I think that was a pretty good system. I love my fellow Americans. I think that they can get in there, and if they can just get in there and pay attention and focus and let the other people get there. We don't know the inner workings of what all you do. You're watching it.
I think
from
adequately.
A technical standpoint.
I think adequately instructed and willing to follow the Constitution. I believe it's the closest we ever get to achieving justice is in the jury trial system. Now, we have covered stories on air before, Austin, where juries were instructed. They had two verdicts and they were both guilty. Guilty by premeditation or guilty, that's not, that's a jury that can't really be blamed for reaching an unjust result because they weren't instructed appropriately. That's a little different. Or, you have a jury in the first Vanderbilt trial that 11 of them were fine, but one of them was not. And that's not appropriate. That's not our system. So I believe in strict adherence to the system we have. I think our system is fine and will work, but it has to be employed appropriately and correctly, is my belief.
I'm pro-victim. I couldn't be on this jury. And there's video. I haven't seen it. You've seen it. I haven't seen the video. So there's something done.
I'll tell you, the audio is going to be substantially more of a hill to climb for the defense team than the video. The audio is daunting. That's a daunting piece of proof. When that comes in, when you hear it, and you'll hear a good portion of it. I don't know what different stations are going to edit, but you're going to hear a good portion of that. One reason I went back to air when the court said we'll be back in 5 minutes with the opening statements is that breaks are never, ever 5 minutes. There's no such thing as a 5-minute break. And we've been out well more than 5 minutes as an example. Yeah.
Well, Judge Watkins has sarcastically said that he'll be happy if the trial starts before the end of the year. So I think we all better get comfortable.
Well, another thing is when we when the average guy's sitting there watching you guys do your job, and that's, thank God for all of you, because somebody has to go do this, as it says in Atticus Finch, and To Kill a Mockingbird. Your daddy's the one that has to go down there and do this.
Yeah.
It's a very unpleasant task.
It's not a popular way to vocate yourself, I'll tell you.
All of it's something. We wish we had a perfect society where there's never one crime committed and didn't even need juries and trials. But unfortunately, we don't have that. So then certain people, they're called into their professions, and they go in there and they do these things. And I'm thankful that we have a system the way it is. It could be improved, and a lot of that depends upon us. It's not just y'all. Y'all don't carry the full burden. That's why those 12 that go in this case 14, they go in.
Are we coming back? All right, we're going to come back, and when we come back, you'll see a video stream of the events. I will not be talking over it. I was doing that because we only had an audio feed, and I wanted to give y'all some extra. Oh, they're going back in court. Okay.
We hope we have a
We
video.
believe we're going to have a video. BB, is that right? We think we're going to have
Yes,
video.
once the jury comes in.
All right. Once the jury is in.
We are with
So
the
when we
jury.
get the video, we'll cut out. If it cuts me out in the middle of a sentence, it does. But, you know, we'll have a jury in and we'll cut out. If it goes to audio for any reason, we haven't worked out the kink of the video stream, I'll go back and put on my headphones and turn into a radio man once again. I am a professional radio broadcaster, and I will call
Radio Free America.
I will call the action for you, as I did for high school football for 14 seasons. I'll call the action for you and try to give you as good a coverage as we can, as our resources permit.
Two youth coaches who've also sat as defendants.
Mm-hmm. Yeah.
That's what we both have done. We've sat there, heard whatever gets said about us while we're in a courtroom. So we've been on both sides.
Well, one thing's for sure, we're sure bringing you a complete coverage of this
It's
information.
different
And you
from
know,
what
the Dr. Alexander, to revisit that briefly until the jury comes in. This guy, you know, there's some considerable debate about whether being voluntarily intoxicated is a defense to committing an aggravated rape, which it is not. But all crimes require, unless they're statutory offenses or strict liability offenses, all crimes require someone to formulate the evil intent, the evil mind, the mens rea to commit an offense. And to the extent that it prevents someone from developing a culpable mental state, that does make that admissible. And I think we can say that it appears to be the defendant's bent at this trial that they intend to attack whether Mr. Vandenberg was in a sufficient state of mind to formulate the culpable mental state to commit some of these offenses. That appears to be the direction in which they're going to go.
Agree.
We're going to go to break. When we come back, if the jury's seated, you'll come back to video stream. If not, you'll come back to us. You're getting the long version of the Vanderbilt rape retrial.
As far as any evidence or statements relating to the defense family, the presence in the courtroom, or any other irrelevant information, what irrelevant information are we talking about?
I think at some point about perhaps his younger brothers having some medical issue, seemed somewhere in mind there was something brought up about matters totally unrelated to his guilt or innocence in this matter. You have the background information.
Well, Judge, I think it's important for the jury to know that this man is a human being. He does have a family that supports him.
Right, I think the jury would understand that. all of us are human beings, and we all have families, and our families support us, I suppose. But to get into matters that are not relevant is something that either side can object to.
And with regard to the existence of the hostess program, there is evidence in the record that Coach Franklin did ask Ms. Lackey at one point in time to participate in a hostess program. I do not intend to use the word hostess program. At least Ms. Martell and maybe others worked for the football officers and that they did assist in recruiting. And also, DeAndre Woods, in his testimony, used the term hostess program.
Well, I think the state's proposition was that we would have to have a jury out if that issue arose, and we would do so.
Very well.
And also with respect to any 412 issues.
Yes, sir.
Anything further?
Judge, if I may just, again, Ms. Fuller and I were not at the 412 hearing that was held before we came into the case. I know that 412 deals with instances of sexual behavior or sexual conduct by the alleged victim. We do have evidence that they had.
Yeah, you know.
And I object to his statement, this kind of stuff. All I'm doing is talking to the judge.
Gentlemen,
How do you know what I was about to say?
Mr. Reagan.
Yes, sir.
That's an issue we dealt with in chambers for sound reasons. And if we raise those kinds of issues, we will have to do so in chambers. All right?
Maybe do so. Are you talking about right now?
Well, I don't think we need to do that right now. Again, this is something that the state raised and said, whether if some issue comes up, we will have a jury out hearing, and in this particular case, if it's regarding 412, we will have it in chambers. So it's just simple as that.
Well, Your Honor, can we have a brief in chambers then before opening statement? So that I know I don't want to violate any court orders with opening statement.
Well, okay. Well, I'll need to send the jury back down the hall for a minute before we can do that. And I'll grant you that. We can do so. If we can start this trial before next year, I would be happy.
Yes, Your Honor, I would be too.
This is our first jury out of the morning, and the trial technically has not even started. What you're watching right now is our gavel-to-gavel coverage, day one of the Vanderbilt rape trial for Brandon Vandenberg, but the jury has not even been in. We have not heard opening statements. This is a series of motions. You heard there was a long one that really began a little before 9 o'clock discussing whether or not the defense could call a psychologist as an expert witness. That was denied by the judge. And now, Nick, I'm going to ask if you would to walk us through this. First of all, what you noticed right off the bat, I mean, there is some real tension between the two legal teams. Roger Moore firing back right off the bat when he was interrupted by Albert Perez. And then a moment ago, you just saw Randall Reagan get into it with Tom Thurman. So what are they talking about here? It seemed like Roger was saying,
All right, it is we, the long version, and it looks like that they haven't brought the jury back in yet for opening statement. Court Chatter tweeted out a moment ago that they had read the indictment. We haven't seen that on the feed that we're following. We haven't seen that yet. Again, we're anticipating that when the jury's in and seated, that Channel 4 will start streaming on their website that they have given us express permission to use. I want to thank our sponsors. First Choice Moving is one of our main sponsors. They are their phone number is 931-920-5455. They are outstanding. I've used them to move me about 3 times. I don't know that you can do much better than they do. They'll handle everything that you have with care like it was their own. They also can store for you. They're at I think it's 1330 College Street in Clarksville, Tennessee. Again, you can call them at 931-520-5455. I think we got a graphic up there for you as to First Choice. We also want to thank A Way Out Bonding. They're at 931-553-8991. Call Vince. If you're in a jam, they'll get you unjammed. The bonding company is
good to know.
Something that you and I don't know if you've ever had to make bail, but I've had to get a bonding company to make bail for me
between now and Friday to make sure, and up in Davidson County, I have to report in and make sure.
We know A Way Out Bonding actually has an office in Davidson County, okay. So you might give them a call. That number is 931-553-8991. And we want to thank Justin Swallows and his excellent show on WJZM, Saturday Morning Sports Splash. I think it's just called Saturday Sports Splash. It is every Saturday from 10 to 11 a.m. on Clarksville's top talk radio station, WJZM, Saturday Sports Splash. Justin always able somehow, I don't know how he does it, he's always able to line up an unbelievable dais of guests from the sporting world. He's liable to have the head coach of the Titans on there. He really does a fantastic job. And Justin, we appreciate his the efforts that he made to bring this program to you. So we're awaiting on Steve, can you tell us what's going on in the courtroom right now? No. Okay. So we don't know what's going on in the courtroom.
Can I thank somebody? I had to get a haircut. I hadn't been on TV before, so I had to get a haircut.
You look good, Austin.
What's left? And Scott at Cool Springs out in Cool Springs, there's a place called the Grove Salon, and he gave me my haircut. And then the people at FedEx, they're FedEx offices, so when you work alone, you have to always go in. So these guys at FedEx in Green Hills always are helping me and helping me get stuff done. And then these books that I gave you about Shelby Foote and Walker Percy a little while ago, I went down. You can't get a bookstore anymore. There aren't any bookstores anywhere, hardly at all.
I love these books. Let me just say.
And so it's just hard to get a book anymore. I guess everybody's on a phone or a pad, but I like to read a book. And so I finally got Bookman, Bookwoman, down in Green Hills. And I called and I said, "Do you have these old books? Because they're all out of print. Everything's out of print. Nobody's reading them." And so anyway, I was really glad when I was able to get that, because my wife did want me to give you that gift as I visited Clarksville as a guest.
Do we have any questions coming in from courtchatter.com?
No, but he has formally pled not guilty.
All right, so what's happened is that that joins the matter for trial. That's called joining the matter for trial. The government has read the indictment, which are allegations that more likely than not, they believe that this individual committed this offense within the area of where the court is empowered to act and adjudicate. And then the defendant enters a plea of either guilty or not guilty. I don't think I've ever seen a defendant enter a guilty plea at a trial. They enter guilty pleas, but not at a trial. And once that occurs, for all the lay people out there, now the matter is called joined for trial. And believe it or not, I conducted a trial or two in my former career as a trial lawyer where there was an issue as to whether the matter was ever properly joined for trial. I remember one trial that I recollect where I don't believe the court took my client's plea. It didn't make neither hoot nor hoot nanny. I mean, in the final analysis, it didn't matter. But I remember arguing that, Your Honor, if we're speaking technically here, you never actually joined this matter this matter was never properly joined for trial. Some of these technical things, there's not as many technical defenses that are successful as the general lay public believes. More times than not, they're gonna err on the side of letting the jury make the decision. There aren't a lot of decisions in criminal jurisprudence that end up being taken away from a jury. At the end of this proof, the defendant will move for a judgment of acquittal under Rule 29. Why? Because they always do. Defendants always move for a judgment of acquittal. It's almost never granted. I had maybe in over 200 criminal jury trials that I conducted as an attorney, I think I might have had one judgment of acquittal granted, maybe two. But that's a very, very small amount. But that's going to happen. They're going to ask for it.
And for you, when you're citing rules, see, the average guy like me, I hear Rule 29.
Doesn't mean anything to
you,
yeah.
Rule 30 is the rule about whether you can have the media in the courtroom and all that kind of stuff in the Tennessee Supreme Court. But for youth baseball coaches and everybody out there, you carry your little book and you got your birthday certificates that everybody wants to check, make sure everybody's legal that's playing the game.
All right.
And for baseball coaches that really like rules, that it's really, and now that I've now pro se for a while and have been in the courts, it's very intimidating. You're gonna probably lose because you don't know what you're doing and you're up against the lawyers and like I am in the cases we're in. But you're trying to get the book so you can see what the rules of the game are. And the rules say 01, 02, 03, and they go down through there. And so they govern how the game is played in that courtroom.
Well, probably one of the most misleading perceptions there is in law is the belief that because law is authored and penned in English, that means anyone who can read that particular language is going to be able to interpret the meaning of the particular rules and then use them and then incorporate them in practice. And there's a little bit more to it than that.
Yeah.
Actually, I mean, the rules themselves are written in English, but just your ability to achieve literacy doesn't necessarily make you a lawyer.
Yeah.
It's understanding how those rules play out. And again, you've got the lead attorney on the defense side in this case is primarily thought of as an appellate lawyer. Troy Bolin has done a great deal of the lifting thus far in some motion arguments that he's made this morning.
What I was trying to say though was,
are we about to go? Okay, I think we're going to stream from inside the courtroom, we think. So we'll wait and see how this works out.
Those rules are also not to be so daunting that an average guy couldn't go pick up a rule and go, what the hell does Rule 29 say? And just read it.
Well, yeah, you can read it. Yeah.
No, but what I'm saying is, I'm just saying for the average guy, because you don't want it to be such a Wizard of Oz thing, because there's got to be some ability for the citizen to know whether he's getting a fair trial or if they're following the rules. And I guarantee you, once you become a defendant, you start getting a little more engaged in the rules.
Oh, I thought we were going to the feed. So.
When you're sitting over there, and I have sat where Corey Beatty and Vandenberg have sat. I've been taken back into that holding cell and frisked.
Yeah.
And I'm just saying, once you're in that position, you do become where you're very much wanting to know those rules.
Yeah, you're more interested than otherwise.
But then the guy is sitting out watching it on TV.
Yeah, you're more interested than people otherwise would be. Sure. So we're still waiting to hook up with the feed. Any indication of what's going on presently? Are they in opening statements now? All right, we're trying to join the broadcast here. It's being provided by WSMV.
Apparently we aren't the only ones with technical difficulties. Several people who are watching the stream online say that they can't, that they can see but they can't hear.
Okay. So there may be a problem in the courtroom itself with the pool camera.
The jury has left the courtroom. The defense wants to argue that the case should be dismissed because of double jeopardy.
Okay. Wow. All right. Let me explain that. The defendant, the Constitution of the United States says that a defendant cannot be put to trial twice for the same offense. I would love to hear how they believe that jeopardy attached the first time when the verdict was vacated and it was declared a mistrial, because I don't know that I've never seen such a motion work.
For a mistrial?
To ask for the trial to be dismissed because it's double jeopardy because he was mistried the first time. If that were the case, then if a jury hung, you could never retry that case, and it's pretty much well settled law that you can retry a case where the jury the first time hung and a mistrial was conferred. So that's pretty well settled. There's no dispute about that. So this, again, the Perez factor is going to be important in this defense. How many of these motions are motions that this defense team believes to be meritorious, and how many of them are meant to placate someone who, and Perez and Vandenberg are very close. They're personally close. I think Perez was like a father to him.
And in the first case, didn't Perez and the Terminator get into a really heavyweight boxing match going on in the early days where he was accused of concealing evidence himself?
Oh yeah, there was.
They were talking about indicting Perez.
Yeah, Thurman intimated before the first trial that Albert Perez was an unindicted co-conspirator to one of the counts of the indictment. That never went anywhere.
That would not make their
the
blood
the state filed some sort of a motion to have all of us, me included, found in criminal contempt. That was never even tried. I don't know what the point of that motion was, but it was never, they abandoned it, if you will. They filed it and then the government kind of abandoned it. They never tried that. So there was some banter that they were going to move to have Albert Perez disqualified. That didn't, I don't believe that happened either. That may have been argued and the court did not disqualify him, because there's a pretty strong constitutional provision that provides that you should have your attorney of choice if you're being tried for an offense. And Albert Perez was clearly the attorney of choice of Brandon Vandenberg, the two of them being personally very close. But I've wondered in the past if their relationship wasn't too close for him to render accepted legitimate defense. You can't be so close to the defendant that it actually impedes your ability to mount a defense. And I've wondered before if Albert and Brandon weren't too close.
Yeah. Well, the court chatter are people that are sitting out here, and they're average citizens like I am. And I know how people are that follow trials. Trials are fascinating. The OJ trial, and they're having a documentary right now. I mean, it was gripping. Everybody in the country's watching it. They're watching the sidebars. Y'all did your sidebars back in a room where people couldn't really watch the sidebar go down.
Yeah.
Their sidebars with Judge Ito was right there where everybody could kind of see what was going on.
Well, I want to explain that.
And,
in the O.J. Simpson trial, the people of California and the defense would generally ask for the jury to go out, and then they would argue in the courtroom. What Judge Watkins did in the first trial was, in lieu of that, he would leave the jury in the box and let us leave the courtroom and go back into his chambers with a court reporter and argue it back there. I don't know which one of those is more appropriate. I think you can do it either way. And we did have some arguments that were in court that were able to be televised. I'm kind of glad that some of the stuff that we said back in the back, I'm kind of glad was back in the back, even though there's a transcript of it, you can order it if you so choose. I'm kind of glad that some of it was left back in the back, because it got pretty ugly back there, to be honest with you.
As a guy that got banned from that trial, I would rather be done in there where everybody can see what's going on rather than be done. I understand them not wanting to move the jury or whatever.
Yeah.
But again, I still say there is a real lack of confidence in the judicial system and police and a lot of things going on. And I just think the more transparency and openness that's happening makes the public have a better trust in their government and in the judicial system.
Well, you're right about that, Austin.
And
when you start going in the back a lot, the rumors of what you're doing back there and how you're trying to pull a fast one.
Or somebody's getting in almost having fight. I mean, I think people like to see if they're people getting animated like that in the courtroom,
Well, it's good theater.
Yeah, well, that's what it is,
theater.
though. I mean, it's people are on trial for their lives.
For those of you that are wondering, you're getting the long version of the Vanderbilt rape retrial. Is being sponsored by First Choice Moving and Storage, A Way Out Bonding, and the Saturday Sports Splash on WJZM. We're waiting on they're experiencing some technical difficulties, and apparently it is more broad than just we. It appears that we're monitoring internet traffic. We appreciate courtchatter.com as they have kind of participating in this broadcast with us. Kathy Russin will be sending in questions and commentary, and they're commenting even as we speak. Right now in the trial process, we believe that the matter has been properly joined for trial. That means that the government has read their indictment and that the defendant has entered his plea of not guilty in front of the jury. And I think at some point we're going to start the opening statement, and we're trying to monitor when that'll happen. This case is going to be a slow process as they kind of sludge through the apparatus that is the case in chiefs of the government and the defendant. It's going to be a slow process.
And as this all begins, what generally happens is, as a person that just watches from the seat, a couch or wherever it is, all the focus is on the defendant and upon the jury or the lawyers or the judge or whatever. The victim a lot of times is forgotten. I don't know whether she's in the courtroom today or not. And one of the things that's tough about all this is in these feeds, they've not done a very good job of protecting the identity. We don't get to have any control over that, but I just know for me personally, I just haven't liked that when that's gotten out and the victim's name gets out. But I wonder even the toughness it takes, the bravery, all the things to kind of continue to go through these trials. Now it's the third one, and there may be more, and you never know if there's going to be an appeal on the second one or anything that happens there. What's happening there with her and her family? And then also you've got like out in California, just watch what happened with the Stanford case, and then you watch that victim's reaction, and the long letter, all those kind of things. So
I think we're going to be able to go to the feed. The video portion appears to be sort of stuttering, but at least we'll be able to get a good audio feed.
It looks like we're in there now.
We see the feed, thank God. We're getting it from WSMV.
To go from the document.
I feel like we're on Mars or somewhere. We're here and we're trying to get back, and
That's fine, Ron.
This is great TV, I would think. Fletcher, you and I sitting there and being in little Clarksville and
Okay, let's go.
trying to.
Little Clarksville's not so little.
Well, but I'm saying we're not corporate media. We're not the New York Times or anything. We're just two guys that have.
I don't know if they're able to. Are they able to hear us now? Are we on? Okay. Well, what we're seeing the feed now, and I think you're seeing it because I'm looking at a monitor, so you're seeing what I'm seeing. I see Albert Perez
Show them how to place
trolling
it on
around
there.
the defense
He
podium.
has to switch it over.
But it is kind of stuttered. I don't know if the audio's playing or
Like the
not.
first
If it is, I'm talking over it, so I would assume that it's not. But it's nothing made. You can see Brandon in the background there. BB, you got animated. What's going on your end?
You can focus in. Can we take that bottom line off?
It's like watching the first moonwalk.
Can you see it, Your Honor, please?
It is. I'm watching it now. They're really having considerable amount of issues trying
Your
to.
Honor, please, we have lodged with the court this morning a motion to
It
dismiss
looks like Troy
pursuant to the
Bowling
prohibition
is going. Am I saying
according to
his
the
name
United
right?
States
Troy
Constitution,
Bowling
State
or
of Tennessee
Bowling? I think it's
Constitution
Bowling.
against double jeopardy.
They're from Knoxville, aren't they?
Your Honor, please.
Troy, I think, is from Maryville.
I would like to start out by
Am I talking
suggesting,
over? All right,
as
I'll
the
shut up.
statement puts, that the state may obtain a superseding indictment, which is an indictment. Another indictment is still pending so long as jeopardy is not attached. That's Williams v. Stewart. Judge, please. And again, I apologize if these are not as clear as we would like. As this honorable court is aware, the first trial in this case commenced in January of 2015. I have off to the side that original indictment, case number 2013 C2199. That was the first trial that commenced in state of Tennessee versus Brandon Vandenberg. On that same day, January the 13th, 2015, jeopardy attached. I do not believe there would be any dispute in this room amongst colleagues that jeopardy attaches in a criminal case when there is a jury, when the jury is sworn. And I cite State v. Pennington. In a jury trial, jeopardy attaches when the jury is sworn. So from this, we gather on January the 13th, 2015, a jury was sworn. This is a cite to that case. Jury was sworn, jeopardy attached. Customarily in jury proceedings, jeopardy attaches when the jury is sworn. In non-jury proceedings, it would attach when the first witness is called. That's State v. Pennington, cited by Chris v. Brett. That's another part of that particular. So we take, again, Judge, from this, we take that on January the 13th, 2015, a jury was sworn in to decide the case of State of Tennessee versus Brandon Vanderbilt. When does that jeopardy end? Jeopardy ends when the case is terminated. Upon a mistrial, jeopardy continues. And I cite Richardson v. United States, the jeopardy that attached when the jury was sworn continues until there is some event that terminates the original jeopardy. And that's key, terminates the original jeopardy. A mistrial does not terminate the original jeopardy. Also citing Yeager v. United States, the initial jeopardy, that is that jeopardy of January the 13th, 2015, that commenced when a jury was first impaneled, continues after mistrial. Last year, April, June, this court declared a mistrial as it relates to State of Tennessee versus Brandon Vanderbilt. That mistrial was declared. What we take from these cases, after mistrial, the jeopardy continues in case number 2013 C2199 as a mistrial has been declared. I also cite for the court Richardson v. United States. And we reaffirm the proposition that a trial court's declaration of mistrial following a hung jury is not an event that terminates the original jeopardy. The state has declared yet this morning that that original case is still pending, that original case is still there, and that it has not been terminated. The original jeopardy to which the petitioner is subject, the government, like the defendant, is entitled to a resolution of the case, a verdict of a jury. That's the Richardson case that I cite. Just to keep things in order, I pull out the language of that Richardson case, as I'm sure the court is following along. That's just the language of the Richardson case that I just cited. And we reaffirm the proposition that a declaration of a mistrial is not an event that terminates original jeopardy. So we have jeopardy, we have continued jeopardy in case number 2013 C2199. That's citing Richardson. I point the court's attention to Yeager v. United States Supreme Court case. We have held that the second trial does not place the defendant in jeopardy twice. Well, why is that? Why does a second trial, after a mistrial, not place a defendant in jeopardy twice? The reason why it doesn't place the defendant in jeopardy twice after a mistrial is simple. The jeopardy is continuing. The whole years ago, when double jeopardy was being litigated, after a mistrial, those that had been convicted, or those that were mistrial had been declared, said you can't try me again because double jeopardy prohibits that. No, double jeopardy doesn't prohibit that, because when a mistrial is declared, the jeopardy continues. The jeopardy is attached, the jeopardy continues until there is an event that terminates that jeopardy, an event that terminates the jeopardy. And we go on, manifest necessity that permits the declaration of a mistrial and the continuation of the initial jeopardy that commenced when the jury was first impaneled. So with that said, Judge, jeopardy was attached, jeopardy continues, And the state stipulated in their response to our previous, and please don't confuse this with our motion to dismiss the superseding indictment previously litigated. The state stipulated that jeopardy had attached. In fact, they cited the case of Tawana Blair, and they said in so holding, the court also addressed double jeopardy implications and reasoned the subsequent indictments were not prohibited because jeopardy was continuing from the declaration of a mistrial. This is the state's response to our original motion to dismiss the superseding indictment. Judge, we filed a motion to dismiss this superseding indictment because, in fact, we are of the opinion that the state cannot file a superseding indictment. The filing of the superseding indictment and the jury which was just sworn in is why we're here today. We wouldn't be here having this argument today had the state not lodged a superseding indictment and allowed a jury to be sworn in on the superseding indictment. Had they left things the way they were, had they left things the way Blair says to leave them, had they left things the way Richardson said to leave them, had they left things the way Williams v. Stewart said to leave them, we wouldn't be here. Williams v. Stewart makes it very clear that the state may obtain a superseding indictment at any time prior to trial without dismissing the pending indictment, and may then select the indictment in which to proceed under. 2012, the state may obtain a superseding indictment, which is an indictment obtained while another indictment is still pending, keywords, if jeopardy has not attached on the first indictment. Williams v. Stewart. If jeopardy has not attached on the first indictment. In January the 13th of 2015, jeopardy attached to case number 2013 C2199. This case is clear. The indictment off to the right, the 2015 indictment, should not have been allowed, should not have been allowed respectfully by this honorable court. Wouldn't be here today. States blew their opportunity, Judge. No superseding indictment may be attained after jeopardy has attached. This is State v. Johnson. I cite that case. And they use some language that's interesting. I heard General Moore talk about the tardy bail earlier. They used some language that was interesting. This continuing jeopardy, the jeopardy that attached on the first case, means that for purposes of utilizing a superseding indictment, the tardy bail had already rung when jeopardy attached in the first trial. Too late. The tardy bail had rung when the jeopardy attached on January the 13th, 2015 to case number 2013 C2199. Here's an illustration. Try to do the math in my head thinking maybe something was deceiving or that I was missing something as I was preparing this argument. A jury has been sworn twice. We had a jury sworn January of 2015. We had a jury sworn today, June the 13th, 2016. 1 + 1 = 2. That is 2 jeopardies on the same sets of facts in this, which is the honorable court. If the honorable court remembers, this honorable court, when they were faced with the first fallacy of the original indictment, ordered that indictment was sufficient to charge aggravated sexual battery, and that court acknowledged that again in the superseding indictment. It was in fact the same charge. It was in fact the same set of occurrences. It was in fact the same set of facts. 1 + 1 = 2. Another word for that is twice, and I have cited State v. Johnson that talks about a defendant cannot be placed twice in jeopardy. This is a highlight. The court ordered by denying our prior trial motion on Mr. Fletcher Long and John Herbison. When they raised that issue, this court said this indictment is sufficient to charge aggravated rape and aggravated sexual battery among those charges. This court ordered that when the jury returned a verdict which was essentially set aside. The court said that indictment's okay. The court said the superseding indictment's okay because there are no new charges. By allowing the state to proceed on the superseding indictment, Mr. Vandenberg has and is now in jeopardy twice. Judge, prior to this morning, the state, had they have acknowledged the position, the pickle they have placed themselves into, could have walked into this honorable court and dismissed the superseding indictment, and we wouldn't have been faced with the decision, the untenable position that this court is in today. However, they allowed a jury to be sworn in. Mr. Vandenberg enter his pleas of not guilty to this case, which now has been twice placed in jeopardy. And this is a case, Richardson v. United States. Despite the argument's textual appeal, we have held the second trial does not place the defendant in jeopardy. What Richardson State is talking about, the continuing jeopardy that attached to the original mistrial. This is an illustration that I placed before the court, Judge. It's factually true. There is no dispute. We have jeopardy that attached this morning in case number 2015 C-1517. That jeopardy attached at about 10:30 this morning when the jury was. Well, Judge, think about that. Do we dismiss the superseding indictment? We'll talk about that. Do we dismiss the case in its fullness? We'll discuss that. Do we continue on the original indictment, case number 2013 C-2199? Dismiss the original indictment. Double jeopardy, long held right, constitutionally protected, says you can't dismiss, well, you can dismiss the original indictment. Double jeopardy prohibits reprosecution. If Your Honor will recall, when I spoke about an event terminating the original jeopardy, a dismissal terminates the original jeopardy, which then in fact bars reprosecution pursuant to double jeopardy standard. If the original case is dismissed, the jeopardy which attached and is now continuing terminated, that's why I use the word terminated, thus prohibiting a second indictment. That original jeopardy that was attached and is continuing in case number 2013 C-2199, that attached on January 13, 2015, if it would be terminated by this honorable court, then the state could not proceed under any measures because that case had in fact been terminated. Richardson, United States Supreme Court, Yeager case lays it out very clearly. If the original jeopardy has terminated, it's clear, then the state would not be permitted to retry the defendant. So if this honorable court was to dismiss the original indictment, the state would therefore be barred from prosecuting Mr. Vandenberg under a superseding indictment unless, in fact, there are some facts or some allegations or new charges that's totally unrelated to the facts that they're on notice of, and we're on notice since 2013. I pointed that case out again, highlighted that language. If the original jeopardy has terminated, then the state would not be permitted to retry the defendant. That's speaking of dismissing the original indictment. Do we dismiss the superseding indictment? The superseding indictment, respectfully, Your Honor, please, was unlawful and prohibited by the authority in the state of Tennessee, the United States Supreme Courts, as we cited in our motion to dismiss the superseding indictment. It is barred by both our Constitution, this great state of Tennessee, and the Constitution of our great land, the United States. Williams v. Stewart talk about superseding indictment. The state may, have a 2012 case, the state may obtain a superseding indictment, which is an indictment obtained while another indictment is still pending. Key, if jeopardy has not attached on the first indictment. Should the court dismiss the superseding indictment, here's what we're faced with. The jury's been sworn in. The jury has been read case number 2015 C-1517. Jeopardy has now attached twice to the same charges, the same sets of facts, the same group of occurrences to which Mr. Vandenberg has now been placed in jeopardy twice. The court cannot go back to this jury and read the original indictment. The jury must be excused as that indictment 2015 C-15 has been read and pleas of not guilty have been entered on behalf of Mr. Vandenberg by Mr. Vandenberg. Do we continue on the original indictment? Sure. Jury's got to be dismissed. This honorable court's going to have to dismiss the superseding indictment. Jeopardy has attached. Jeopardy is continuing. And it is permitted. It is permitted by the authority and is not prohibited by double jeopardy to continue on the original indictment. But here's where the rubber meets the road. The government will be permitted to retry the defendant because the retrial is not truly a second proceeding that would violate the double jeopardy clause. We have to keep that in mind. When jeopardy has attached and jeopardy is terminated, what bars reprosecution? Our founding fathers, double jeopardy prohibits the state from proceeding. If they were to dismiss, if your honorable court were to dismiss the superseding indictment, Judge, it is a vicious circle. You dismiss the first one, can't proceed on the second one. Dismiss the second one, can't proceed on the first one. Why? Because jeopardy has attached twice. We should never be in this position that we are in today. The state got greedy. The state tried to cure a wrong, and they have placed themselves in a position to where they have blown it. This court must dismiss this case. There is no factual way around it. Mr. Vandenberg, as he sits here today, is faced with being placed in jeopardy twice on the same set of facts, same set of occurrences, same charges as this court has ordered, and the same charges as the state. The state, when they're citing Tawana Blair, says, oh, Judge, it's the same charges. We can bring this. We can bring this. We'll talk about Blair, and we'll talk about how this court has been misled as it relates to Blair. We're going to talk about that. This court must dismiss this case. There is absolutely no way around the double jeopardy prohibition. The jury's been sworn. Double jeopardy clause prohibits multiple convictions, and keywords, multiple prosecutions for identical offenses before any conviction can stand. There is no way around the position that Mr. Vandenberg is in and that this honorable court must decide. Let's talk about State v. Blair. That's the case that the state relied on. The state heavily in their argument to the court when they were so anxious to get this superseding indictment. If it didn't charge new charges, why bring it? Well, we know why they brought it. They knew the first one contained fallacies. They knew that it was fatally defective, or you should have left well enough alone. If it's not broke, don't fix it. They tried to fix it wrong. State v. Blair. In January of 2017, Miss Blair was indicted, and these are important case numbers. 2017? 2007. Sorry, okay. Getting ahead of myself. Miss Blair was indicted, and these case numbers are important, and I will forewarn the court this gets tedious. In case number M07003, she was indicted with 3 counts of conspiracy to commit first-degree murder and perjury. That's Miss Tawana Blair. That's the first case, 2007, Judge. In May of 2008, the state dismissed case number M07003 the 3 counts of conspiracy to commit first-degree murder. They didn't dismiss that case in its entirety. They dismissed the 3 counts of conspiracy to commit first-degree murder. This left the original count on that charge of perjury. If the court recalls, the page before that, there were 3 counts of a conspiracy to commit first-degree murder and perjury. When they nollied the 3 counts of conspiracy, it left the perjury count still pending. In March of 2008, there was a new indictment. That was case number M-8-125. They indicted Ms. Blair for 1 count of conspiracy to commit first-degree murder and 1 conspiracy to commit aggravated robbery. So at this point in time, when they indicted her, re-indicted her in a new case number in 2008, she was left with those 2 counts we see, as well as the perjury count that was remaining from case number 07003. At an unknown date in that same case, the conspiracy to commit aggravated, and I put robbery should be there, was dismissed in that case number 0125. And so we all don't have to try to decipher this. I hope I laid this out well enough. This is what was left after those 2 indictments and those group of dismissals. This left case number 08-125 with 1 count of conspiracy to commit first-degree murder and 1 count of perjury in case number 07003. Those are 2 different case numbers. Those are the 2 remaining counts that was left over after they had went through their series of dismissals and indictments and re-indictments. In October of 2008, there was a 3rd indictment by the state of Tennessee prosecutor's office, in case number 08-455. That 3rd indictment indicted Ms. Blair with 1 count of conspiracy to commit especially aggravated robbery, 1 count of especially aggravated robbery, and 3 counts of felony murder. And I made a note that the especially aggravated robbery was the underlying felony as to the felony murder count, Judge, please, in that case. What are we left with? We're left with 3 case numbers. We're left with 08-125, 1 conspiracy to commit first-degree murder. We're left with 1 perjury, 07003, and we're left with this brand new indictment, 08455, in which there was 1 conspiracy to commit especially aggravated robbery, and 3 counts of felony murders. That is what Ms. Blair was ultimately left with up until this point. Those were the charges that were pending against her that had not yet been dismissed. No trial had been had at that point in time. At an unknown point in time, the court joined case number 08125. Your Honor, I'm passing up the Tawana Blair case just so you'll have it.
What?
I'm passing
I
up.
have the Blair case.
You have the Blair case? Okay, very well.
I do.
At some unknown time, the court joined case number 08125, the 1 count of conspiracy to commit first-degree murder, and 08455. The court joined those 2 cases. Keep in mind the perjury count was not joined. It's just been lingering ever since 2007. But the court joined those 2 cases. Prior to trial, prior to the trial in 2009, there was a motion filed, and the conspiracy to commit especially aggravated robbery was dismissed upon the motion of defense counsel. That was that last case number we spoke about. And that left 1 especially aggravated robbery, 3 counts of felony murder, and 1 conspiracy to commit first-degree murder. Out of all of those cases, out of all the cases that were joined, that's what was left. Prior to trial, the Honorable Trial Court ordered the state to select its charges. What are you going to try? What charges are you going to present to the jury? The state selected case number 08-455. That was the felony murders, and that was the especially aggravated robbery, which was the underlying felony for the felony murders. The state did not proceed, and this is key, on the first-degree murder case, the conspiracy. That is case number 08-125. The state did not proceed to trial in that case. During trial of the 08455 case, the defense moved for a judgment of acquittal. The Honorable Court reserved it. The defense renewed their motion for judgment on the acquittal. After the proof of the defense, the court reserved ruling, the jury became deadlocked. The court revisited the motions and granted the motions for judgment of acquittal. And this is kind of where it gets a little confusing, but the court granted the motions for judgment as acquittal as to the 3 felony murder cases, the especially aggravated robbery case. Court also entered a judgment of acquittal as to the lesser included offenses of second-degree murder. The court was asked, Judge, please, to also enter a judgment of acquittal as to the lesser included offenses of second-degree murder, facilitation, and the like, and the court refused to enter a judgment of acquittal as to that. Immediately, the state filed a motion to reconsider because the court had granted the judgment of acquittal as to all the charges. The defense filed a motion to reconsider because the defense believed that they should have had a judgment of acquittal as to all the lesser included offenses, including facilitation. Trial court granted a Rule 9. While it was pending, the state filed a motion to recuse the court. Judge was recused, and the Honorable Judge John Kerry Blackwood, our most recent senior judge of the judiciary, was appointed by the administrative office of the court to take this case on. While the appeal was pending, the state nollied case number 08455 in its entirety. The state nollied that case that had went to trial in which judgment of acquittals were pending. While the Rule 9 was pending, they issued judgments of motions. They dismissed that case. So here comes the state again. March 2014, they got a new indictment. In this new indictment, case number 14 CR 158, they charged 2 counts of conspiracy to commit first-degree murder. And I make a note, there was no previous trial on the charge. Remember that conspiracy of first-degree murder was always there, was never tried. The state elected not to try that. No jeopardy had attached, no jeopardy was continued. They had also charged conspiracy to commit a special aggravated robbery. They had also filed a facilitation of the special aggravated robbery and facilitation of first-degree murder. They get creative because the court didn't dismiss on judgments of acquittal the facilitation. So the state said, well, here's our opportunity. We can indict for facilitation of first-degree murder and facilitation of a special aggravated robbery because the court didn't enter judgments of acquittal as to those charges. What did the Honorable Judge John Kerry Blackwood do? The court dismissed it. Dismissed the case. The court dismissed the conspiracy to commit a specially aggravated robbery, the facilitation, as the statute of limitations had ran. The court dismissed the 2 conspiracies to commit first-degree murder. And that's important, and it's important because this is my second argument that I'm going to talk about. Not only is the state barred by double jeopardy principles and all the standards that come along with that, but they're also barred by this subject to mandatory joinder under Rule 8. You have to remember, Judge, in this case, please, court, that the original conspiracy to commit first-degree murder was never tried. Jeopardy had never attached. And the Honorable Judge John Kerry Blackwood, which was upheld on this case, said, you're right, but guess what? You had to mandatorily join it with the other case. You failed under Rule 8 to join. And the court on the facilitation dismissed the facilitation for the reasons stated as to the Rule 8. The state argued double jeopardy does not prohibit the re-prosecution. The Court of Appeals agreed, but only as to the conspiracy to commit the first-degree murder, which was not tried. That's when I spoke about that. The court said, you're absolutely right. Double jeopardy doesn't prohibit it because jeopardy had never attached on that particular charge, on that particular count, because you had elected not to try that particular count. Am I? Thank you, Mr. Perez. Double jeopardy. This is taken from Blair, straight from the Blair case. Pennington. A double jeopardy violation arises only when an individual is twice placed in jeopardy for the same offense. Here, Mr. Vandenberg has in fact been twice placed in jeopardy for the offense. And in this case, in Blair case, the court says the same thing. Here the defendant was not twice placed in jeopardy for the offense of conspiracy because it had never attached. They elected not to try that. And they said, however, Rule 8 prevented the prosecution of that particular case. Talk about Rule 8. Very strict rule. Tennessee Rule of Criminal Procedure 8A governs the procedure for the mandatory joining of offenses. Criteria for mandatory joiner, 2 or more offenses shall be joined if in the same indictment, presentment, or information with each offense stated in a separate count, or the offenses consolidated pursuant to Rule 13 if the offenses are based on the same conduct or arise from the same criminal episode within the jurisdiction of a single court, and know to the appropriate prosecuting official at the time of the return of the indictments. All 3 of those are satisfied. They knew, they have known, they've always known. Nothing about that does not fit. And it's clear. Failure to, and again, this is my second argument. Failure to join such offenses, a defendant shall not be subject to separate trials for multiple offenses falling within the Rule 8 exclusion. King v. State, Your Honor, please. 717 Southwest 2nd 306. He was originally indicted with 1 count of assault with the intent to commit murder in the first degree. Tell this is an old case. And the trial court had erroneously instructed the jury as to an offense. That was reversed. The state subsequently indicted for a malicious stabbing. And the key point to this particular part is what that case, King v. State, cited. To prevent a defendant from being subjected to separate trials for multiple offenses when the multiple offenses are barred or are based on the same conduct or arise from the same criminal episode if the subsequent charge was not known to the state. The state knew about this when they filed a superseding indictment. There's nothing they did not know. King Court was very, very bold. And they said, we do not perceive that any evil results from subsequent indictments being returned against a defendant, charging him with additional offenses which are based on the same conduct or which arise from the same criminal episode upon which prior indictments have been returned, when the defendant has not been tried on any of the offenses at the time the subsequent indictments are returned. This is good law. It's standing law. It has not been overruled. Further, in Luther and Fowler, this court interpreted Rule 8 to bar any subsequent indictments after the declaration of a mistrial for any offenses known at the time of the first trial. Rule 8 continued in its advisory comments. The court stated that the rule was clearly meant to mandate the joinder in a single indictment of all the offenses known at the time to have been committed in a single criminal episode. State v. Blair. This is language from that case. The court observed that whether evil results flow from its breach or not, mandatory joinder of the known offenses is absolutely required. And the sanction is a denial of a prosecution is the denial of the state of a trial upon a charge made in violation of this rule. Judge, the only hope the state would have had if they were so committed to wronging or to righting their wrong, to fixing their mistake, would have been to file a superseding indictment, although unlawful, based on the authority, and then ask this court, please let us join these under Rule 8. Please let us join these. And then they could dismiss potentially the surplus counts that they chose not to go forward on. That would have been their only hope, and we would submit that under Rule 8 they couldn't have even filed, they could not have even joined them because they knew about them. I read that language. They knew about them. Same criminal episode. It's no new offense. And what Rule 8 talks about is if somebody gets on the witness stand and somebody talks about a different crime, and then there's a mistrial, and you investigate that different crime, and you want to supersede indictment with a new crime on facts you didn't know about, absolutely, this is not the case here. This is absolutely not the case here. The state of Tennessee has put, this court had blew their shot at prosecuting Mr. Vandenberg based on greed, based on trying to get this court to right their wrong. Had they left the original indictment alone, jeopardy continues, we would not be standing here today. We'd be in trial. We'd be in opening statements. They got greedy. They tried to fix the wrong. If there was nothing wrong about it, why file it? They knew it was wrong. And they filed it. And this court allowed them to file it. And respectfully, Judge, we would not be in this situation had the key here is now the jury's been sworn in. Had this honorable court been given the Tawana Blair information when the state tries to tell the court, oh, you can supersede indictment. Tawana Blair says you can supersede indictment. They give you all the facts. These are the facts. You cannot supersede indict after you have went to trial and a mistrial declared the tardy bail has run. And the state asked this court to fix its mistake, to fix its invalid indictment. And fortunately, for a temporary period, this court has allowed that to happen. Unfortunately, allowed it to happen and the state allowed it to happen up until a point today when this jury was sworn in, and we have two big red stop signs up here that says jeopardy's attached. Twice, not once but twice. The state of Tennessee is barred from prosecuting Mr. Vandenberg pursuant to the prohibition of double jeopardy and pursuant to the mandated governances of Rule 8. If the court even goes there, they are barred from prosecuting Mr. Vandenberg on this superseding indictment, and in fact they are barred from prosecuting Mr. Vandenberg on any indictment as it relates to these sets of facts and these occurrences. The tardy bail had rang when they superseded the indictment. Again, had the state not tried to use this court to right their wrong, we would not be in this position today, but we're in it. We ask this court to dismiss this case.
All right. State.
Judge, I know the court can see all the various boxes and buckets of we've brought over here in anticipation, and I will say that Mr. Bowling gave us enough time to bring over the one box that I didn't bring, and that was the one that had what I thought we had addressed and previously their motion to dismiss the superseding indictment, which the state sees this as a revisitation, perhaps a reconsideration of that in some part, but certainly with a different framework. Would point out, without asking Ms. Halstead to get but I would, since I only have one copy, is this up?
It'll be up in a moment.
Oh. Pardon me. And talking about the Tawana Blair case, which is, as the court knows, is the Rule 8, the joinder and superseding with additional charges and things of that nature, that if you notice that in the state's response to the defendant's motion to dismiss the indictment, yes, we cite the Blair case, but point out that they cite, the Blair court that is, cites to the state versus Vukolich and Hilliard, where mistrials were declared on all counts after trial. That is the situation here, not the mix and match of the Tawana Blair. The language in Blair, yes, but what happened in Mr. Vandenberg's proceeding was all counts, and actually, again, I would submit this to the court if we need it, but I know we argued, I'm pretty sure we did, State versus David Johnson, Criminal Court of Shelby County appeal, filed March 14th, 2001, for the basic matters contained in that, which is the paragraph, considering the interests sought to be protected by the double jeopardy clause, it logically follows that if a defendant requests a mistrial, he gives up the right to a verdict by that impaneled jury. This was requested by the defense. The court had a hearing and found that the jury, as constituted in the original trial, thanks to juror number 9, was essentially unconstitutional. That he did not receive a fair and impartial trial because of that juror's misstatements. Such that he may not be retried. The cases stand for that. It is, I submit, an issue the council certainly has the right to raise, preserve if necessary, but we should bring the jury back in and proceed with this matter. There is nothing wrong with what the state has done in this case. He is back to square one. He has not been placed in jeopardy as far as being punished twice for the same offense. It's a valid indictment. We submit that we should go forward.
All right, Mr. Bowling.
Briefly, Judge. Double jeopardy doesn't talk about being punished. Double jeopardy says cannot be prosecuted and or punished. Prosecuted twice. And I will point to the Blair case, and under head note, right above head note 8, it's clear. The court observed that because the defendant's trial ended with a hung jury, and Judge, I'm trying to find the page here if I can. It's page 7, right before head note 8. The court observed that because the defendant's trial ended in a hung jury, a second trial on the original charges was necessary, whether the new charges were brought at all. The court further stated that following a mistrial were a new trial on the original charges. And I agree that we asked for a mistrial and we were granted a mistrial. And we agree that we could have been put to trial on that original indictment and there would not be a double jeopardy issue. I hope I'm making that clear to the state. We're not saying that. What we're saying is where the rubber meets the road is where the state filed a superseding indictment with the exact same set of facts, with the exact same charges as ordered by this court, with the exact same set of occurrences, and now has allowed a jury to be sworn in. There is absolutely nothing wrong, and we wouldn't be having this conversation today had the state left well enough alone. The original indictment, there's jeopardy attached. He keeps saying you go back to a clean slate. I don't know what is not clear about the law when it says jeopardy continues. A clean slate is jeopardy not even attaching. Jeopardy attached. It attached January the 13th, 2015. They cite in their response that it attached and it's continuing. To today, it's continuing. We don't need to ask them why they filed a superseding indictment. And they're sitting here today without acknowledging that jeopardy is continuing on the first one and that jeopardy has just now attached on the second one. It's unfortunate that this court is in the position that it's in today to have to clean up what the state has messed up. The state has blew their opportunity. Should the court not dismiss this case in its entirety, then it is left with no other choice but to dismiss the superseding indictment. And they must proceed on the original indictment. The case law is clear. Once a mistrial is granted, that jeopardy continues. And the reason why it's clear and the reason why it continues is because you have to go to trial on that indictment. If there was other charges, if there was new sets of facts, if there was evidence that was discovered, sure, they could have filed a superseding indictment, just like in Blair. They elected the offenses. They didn't go to trial on one. They tried to bring that charge back up. The Court of Appeal said, well, you can bring it back up all you want to, but Rule 8 prohibits it. The state didn't even ask to join these cases. They want you to read Blair. They want you to follow Blair under Rule 8, but don't apply it to us in this situation. If this case, if it were to proceed, which I believe, and it is my conviction that this case must be dismissed in its entirety. If this case were to proceed, it must proceed on the original indictment. Thank you.
All right, thank you both. Well, the court has been presented with a lot of information here, but as of this moment, the court is going to respectfully deny the motion to dismiss. The court will review the materials and we'll see what happens after that. But right now, we will proceed.
Judge, this is not an argument, but since I mentioned the Johnson case, may I provide the court a copy of that?
Sure, that's fine. Okay, we're going to bring the jury in. We'll see how far we get on opening.
We have to take a brief break.
Sure you can. I mean, I realize you haven't had a break. I just realized that. Okay. We'll take a brief break. All right?
All right. Brief reset.
back, and we just saw the defense try to argue a motion to dismiss the superseding indictment. Was one of its applications. The alternative application was to dismiss the entire thing. And it's kind of interesting to me that we're being sponsored by a wait out bail bonding, because that's what Vandenberg's defense team was trying to do, was find a way out for Brandon from being prosecuted. It was not successful. The judge respectfully denied the motion. The motion had some merit, and I'll tell you where. If you will recall, in the first trial, it was argued by me that the indictment failed to state an offense. The government argued that the indictment was sufficient to state an offense, but then after the mistrial was declared, they went and superseded the indictment and attempted to fix the infirmities that we argued by motion existed in the initial indictment. That's where Mr. Bolin was getting his position that if it ain't broke, don't fix it. And when they went in and fixed it, they created a second charge with the superseding indictment on basically the same facts, that to prosecute under that indictment, after it was joined for trial, after they read the indictment and the defendant entered a plea, it was joined for trial, that in essence put him to trial twice based on the same set of facts. That was the argument. Now, I don't think that argument avoids the whole prosecution. That argument may dismiss the superseding indictment and forces the government to go forward in the initial indictment, which the argument was last time that that indictment was infirm, that it didn't really state an offense.
For us that are laymen out here that don't understand all that.
That means he was going to be tried regardless.
But what I'm saying is, in the first one, are you saying that when the government put together an indictment on him, that the indictment didn't describe a defense?
It didn't describe the offense that was charged. The problem with the indictment, I'm going from memory. Now, I argued this. The problem with the indictment is that it failed to set forth one of the material elements of an aggravated rape. I don't recall. I think it might have failed to say that she was unconscious, is what my recollection. Now I'm going completely off memory. My recollection was the first indictment failed to say that she was unconscious. Now, what does that mean? Well, that means if she's not unconscious, then it wasn't an ag rape. And I think it also failed to allege that she was subjected to a sexual assault by force. So the argument is that at worst, this indictment sets forth some sort of a sexual battery or a sexual assault, but it does not allege either the offense of rape or aggravated rape, because a material element that would have to appear in the charging instrument doesn't. That was the argument. Now, we lost that argument. The court ruled that it satisfactorily stated an offense for both ag rape and rape, and we went to trial, and it was tried to a mistrial. You know, everybody knows what happened. Now, the problem here,
after the mistrial,
the government comes in and fixes the indictment.
How come it wasn't right when they began? I mean, don't they do this all the time?
But they said the indictment was fine. Okay, they argued the indictment was fine, but then after the mistrial, they came in and repled it. They redrafted it. They represented it. And after the mistrial, and it's that indictment that Mr. Bolin has argued should be dismissed, because that is in essence instituting a second trial on basically the same facts and violates the double jeopardy clause, which generally the double jeopardy clause is not violated when a matter is mistried and then retried. So that was the argument, that you have to try the first matter, you have to try it on the first indictment.
It's saying they're bringing something new against him after the first one ended in mistrial.
Yeah, they're bringing a new indictment, for really the same facts, and that's the argument. Now, the argument was never going to work. Judge Watkins was, can you imagine what the offshoot or the outrage that would have been engendered this close in time to Brock Turner in the Stanford swimming rape case getting a 6-month sentence from a judge where the prosecutor was recommending 6 years, and then to have Judge Watkins come in immediately on the heels of that where they're starting petitions and trying to recall this judge,
Yeah.
and then on the heels of that he grant a defense motion to dismiss the superseding indictment and force the government to go to trial on what was originally pled, which would have had really no net effect. He still would have been tried, but can you imagine what the outcry, what the anger would have been had he granted that motion?
Fletcher, I'm having trouble getting my mind around the fact that the trial, I guess the rape happened in 2013 and the trial started in 2015, and that there would be something flawed about the.
Well, I will say
from
this.
y'all's perspective,
I'll
something flawed.
I'll say
that
this.
gets corrected.
I'll say this. I'll say this. We noticed the error, what we thought was the error in the indictment. We waited strategically. It was a decision on our part. We waited till the jury was sworn the first time to argue the indictment should be dismissed. Then we argued that after the jury was sworn, because any time up until the jury getting sworn, the government is free to supersede its indictment.
Yeah.
And you
It's
know
like
that
an
was
amended complaint
and so the argument
Yeah.
that the government made when we argued this motion was, you guys have to bring this in a pretrial motion. Well, you don't have to bring it in a pretrial motion if the indictment states an offense, but it doesn't state the offense returned. See, our argument was this indictment states an offense, it just doesn't state an offense for ag rape or rape. It states some other offense, a lesser offense. That's why we told the judge that we didn't have to bring the matter up pre-trial. Of course, you bring the matter up pre-trial, the government goes and supersedes its indictment, they fix it, voila, you've actually told them where they messed up.
But Tom Thurman's the greatest DA in national history.
He didn't present it. He didn't present it. Yeah.
Well, who's preparing that?
This
Who prepares that?
This indictment was prepared and presented by a district attorney, assistant district attorney, who now works for the Office of Professional OPA.
Does anybody review any of it? Do they look
What
at
is
it?
that? Office of Professional Accountability.
I've had a lot of experience.
Okay, all right.
Ignored
All right. This indictment was not prepared. Was neither prepared nor presented by anybody that's on this team. We coming back?
They might be an opening argument.
Okay, we're gonna go to the opening statement. So tune in. We're gonna go right now to the opening statement. You're getting the long version.
And she takes a drink of the blue drink. And Mackenzie had both gone down to get some food to bring back for them, and also to bring Mr. Beatty some food. They'd been to a party earlier that night themselves. So all of them intersect right there in front of Gillette Hall. They have a conversation. You'll see the video. They look. Follow up, go up the steps to get to the second floor where Mr. Vanderbilt's room is. And you'll see surveillance video. They get off the elevator and they drop her like a load of groceries on the floor. and they're laughing. It's funny. And you'll see on the video how Mr. Banks and Mr. Vanderbilt take out their cell phones and are taking pictures of her. Taking pictures of her vaginal area and just taking pictures. You'll hear Mr. Vanderbilt voice that he's upset that his cell phone's running down on him. They then take her and put her in front of Mr. Vanderbilt's room, and then they move her inside. Mr. Vanderbilt has a roommate, Mr. Prelo, who you'll hear testify. He was asleep in the upper bunk, and he'll tell you what he heard and saw next. As soon as they get in the room, Mr. Vanderbilt says, "We're going to F this bitch." A little more gross language than that. And he goes and gets some condoms that he has in the room and hands them out. It doesn't take Mr. Beatty long to get with the program. We don't know exactly what was said out there in the hall. But Mr. Beatty initially, right away, starts penetrating her, pulling her underwear down and putting his finger in her vagina, putting his finger anally into her. And then Mr. Banks gets into the game. A plastic bottle is taken and inserted into her anally. Mr. Banks is there screwing the bottle like this. And then Mr. Beatty, all this is very quick, gets and tries to have vaginal sex with her. That's all happening. And what's Mr. Vanderbilt doing at this time? He's videoing it. He's videoing it and he's encouraging him. Well, you will hear him on the video. You will hear him telling Mr. Banks, "Squeeze that thing, squeeze that thing, squeeze that thing." You'll hear him telling Mr. Beatty, "You ain't even hard, dude." Giving instructions, encouraging. And then you'll hear him laughing. He thinks it's hilarious that this woman that trusted him is being sexually assaulted right in front of him. You'll hear him taunting her, saying, "You want to go back to the tin roof? You want to go back to the tin roof?" While she's laying there unconscious. After that, Mr. Beatty puts his penis in her mouth in attempting to get an erection. He then goes back, has vaginal sex with her. Mr. Banks also goes down and opens up her vagina with his finger and takes close-up pictures of it. Mr. Beatty then, one time during this, which lasts almost 30 minutes, sits on her face and poses for a picture. You'll see that picture. Now, Mr. Vanderbilt wants to get into action during this. He's taking his clothes off. He's over there trying to get an erection. On water on himself. He's having a hard time getting an erection. So what does he do? He goes on his computer in his room and pulls up porn sites to look at to help him get an erection. She's unable to do. There's some worry that she's going to wake up, but not by Mr. Vanderbilt, because he goes over along with Mr. Beatty and slaps her very hard on the buttocks, saying she's not going to wake up. Slaps her so hard you'll see photographs of the palm prints on her buttocks. Now, Mr. McKenzie is also in the room, and you'll hear from him. He'll testify. He was there. He was taking pictures with Beatty's phone and laughing it up. He'd been given a condom, but he didn't put it on. Mr. Vandenberg. You'll hear his testimony. Through all this, then Mr. Beatty finally decides to do the ultimate, to degrade this victim even further. He urinates on her. Urinates on her. That terminates this. Nobody wants to mess with her now since she's been urinated on. So they take her out like a piece of trash and throw her face down in the hall and take some more pictures of her. That, Mr. Beatty's had enough fun, so he leaves to go to his room. Mr. Banks and Mr. McKenzie attempt to leave, But Mr. Vanderbilt tells him to come into the restroom, where he's gathered up the condoms and is in there flushing them down the commode and telling them to assure them, it's going to be all right. Don't worry, it's going to be all right. And then you'll see them fleeing because they start laughing because they're running off and leaving Mr. Vanderbilt there. Mr. Vanderbilt is trying to figure senior star player on the team and kind of a team leader. So he calls Mr. Boyd. Now during this incident, when he's recording this, he's not only recording it, he's sending it out to people. He sends 6 videos out. He's got 2 good friends in California, Mr. Quizino and Mr. Finley. He sends them the videos. And he sends Mr. Boyd one of the videos. And he sends Austin Carter Samuels, who's the quarterback, one of the videos. Now, Boyd and Mr. Carter Samuels are over in another dorm. So once he calls Mr. Boyd then gathers up some folks, Mr. Retta, and gets Dylan Vanderwall up, and they all go over to assist him. And they pick up a person named DeAndre Woods that you'll hear from, who's also on the football team, and they all go up to see what's going on. And at that time, I think Mr. Vanderbilt shows one of the videos to someone in the hall. They're discussing what to do. They then decide breakfast. And the group is now starting to worry. Mr. Boyd's trying to do something as a team leader to maybe contain this situation of what's going on. So there's talk that you'll see some texts that went back and forth between certain parties involved in this as they attempt to cover this up and make sure they get away with it. Mr. Vandenberg has a discussion, and they decide that the best thing Mr. Vandenberg to do is go concerned with the Vanderbilt authorities. And they actually called individuals in to question them, and they questioned Mr. Vanderbilt. He told them, oh, nothing happened. We just took her up to the room. She was really drunk, and I was just taking care of her. And we took her up there, and nothing happened. We talked about football, and no, nobody touched her. No, there were no videos or photographs taken. No, nothing happened. Nothing at all. He did a written statement and a tape statement telling that to Vanderbilt authorities. Well, Vanderbilt authorities are pretty concerned by now. They contact the police department. But by now it's the 27th. It's 4 days after this, which is a problem, obviously, in an investigation like this. And the police come to Vanderbilt, and they review some of the still shots of the surveillance video and see who was possibly involved in this. And then their next step is to interview people. And they interview Mr. Vandenberg first. And you'll listen to that interview, and he'll tell the police, oh, nothing happened. No, nobody did anything to her. I was just taking care of her. Just being a good guy. She was really drunk and, you know, throwing up, and I was just taking care of her. Nothing happened. We talked about football, and, you know, and they left. And, no, nothing really happened. But then the police started doing what they do. They started saying, well, you know, we may find this, and we may sign that. And they're trying to get to Mr. Vandenberg, saying, you know, we know you're a nice guy and you've got a conscience. And they start putting some pressure, I guess, subtle psychological pressure on Mr. Vandenberg, and he's trying to figure out, you know, what they know, what they can find out. So he finally says, okay, you know, I don't trust those 3 guys that were up there. I'm afraid they're going to say something bad about me. I don't trust them. Then he says, okay, I'll tell you. They came in and they were fingering her and stuff, and they were slapping her on the butt. And I heard them having sex with her. They were turning the lights on and off, and it was horrible. I should have done something about it. I didn't. I didn't do anything about it. But it was those guys. But then he says, oh, and by the way, I did take a video of it. And another thing, you know, by the way, I did go out and cover up her surveillance camera. And by the way, I did go flush the condoms down the toilet. And by the way, I did go over and have sex with her to try to cover her up after talking to those guys, that we decided that's what I needed to do. But I didn't touch her in that room. I sat on the bed. So that's his statement to the police, which you'll hear. The police, after that, they bring in experts to come in, forensic experts to come in and do what's called ID. And they'll come in, you'll see photographs of the room, you'll see what's called a Panascan, which you put in there and you can actually scan around the room like you're standing there, and you'll see how small it is. And they collected some evidence. They didn't know exactly what they were dealing with at the time. They collected towels, sheets, things of that nature. Took fingerprints on certain items. And you'll hear their testimony about what they collected. You'll hear some DNA testimony, although because of the lateness of the reports of the police, it was really difficult to get DNA evidence from the victim. And you'll hear about that. But she knew from talking to that it probably was worthless to do that because of the 90-something hours since the attack. And obviously she'd showered and done things like that. But she finally agreed reluctantly to do it. And you'll hear the testimony from the nurse practitioner that did that. She'll describe what various injuries she saw. And she did a vaginal swab. And you'll hear the DNA expert from the TBI testify. Vaginal swab did find a semen from Mr. Vandenberg from what happened the next day. And they did collect some clothes later that she thought she was wearing that night had been thrown in the clothes hamper. They were taken for testing. They tested some towels and things of that nature, and you'll hear some testimony about touch DNA and transfer DNA and things of that nature. You'll also hear from a fingerprint expert, Julia Hooper. Ms. Hooper is going to tell you that she found 3 fingerprints on the condoms, which I think testimony will show belonged to Mr. Vandenberg. One was smudged. She couldn't make an identification on it, but she did identify Mr. McKenzie's fingerprint and Mr. Banks' fingerprint on those condoms that were found in Mr. Vandenberg's room. And you're going to hear from the police forensic analysis detective, Chad Gish, about he did a forensic analysis on each phone. And you're going to see photographs that he recovered from Mr. Vandenberg's phone, Mr. Beatty's phone, Mr. Banks' phone. He didn't recover any from Mr. McKenzie's phone. You'll see those photographs, and they'll try to illustrate what went on over this. Various porno sites. You'll also find that he searched prior to talking to the police whether the police could find deleted videos. So he knew it was possible to find those when he reported to the police that he'd taken a video. And you'll find he also did a search on rape statutes in Tennessee. That was on the computer. Police then knew that he had sent these videos out to Mr. Quizno, Mr. Finley. So in July, they go out to get their phones to do an analysis on them. And when they get there, they don't have their phones. Mr. Vandenberg has been there and destroyed their phones. And also, Mr. Quizno had an iPhone which synced to his computer. Mr. Vandenberg knew that. He brought a program over to erase the hard drive and ran the program on his computer. Luckily, it didn't work totally. Police got a search warrant, got that computer. Detective Gish will tell you that he found 3 video files, very brief video files, a minute and something total of the 6 that were sent. And you'll have to watch those. And in those, you'll see aggravated rape being committed by Mr. Banks and Mr. Beatty. And you'll hear this defendant, Mr. Vandenberg, as he's filming it, laughing and saying, "Squeeze that thing, squeeze that thing, squeeze that thing. You ain't even hard, dude." Taunting her, "Do you want to go back to the tin room? Want to go back to the tin room?" Laughing. That's the proof you'll hear from the state of Tennessee. After hearing that proof, there'll be no doubt this defendant is guilty of each count of this indictment. 5 counts of aggravated rape, 2 counts of aggravated sexual battery, and then disseminating these pictures.
All right, ladies and gentlemen, we're going to break for lunch. As I mentioned to you last week, and particularly now, you cannot discuss any aspect of this case with anyone. Just enjoy your lunch. We will be in break for 1 hour, and we will see you, well, that clock up there is wrong, about 8 minutes after 1. All right? Have a good lunch. All rise.
Okay, we're back, and what you saw there was a very strong opening statement from General Tom Thurman. I want to thank our sponsors, First Choice Moving and Storage. You can call them at 931-920-5455, and A Way Out Bail Bonding, 931-553-8991. And Justin Swallows on the Saturday Sports Splash, heard every Saturday, I think from 10 to 11 a.m. on WJZM. Austin, were you? What did you think? It's somewhat effective that General Thurman got an opportunity to make an opening statement and then have the jury contemplate it over the lunch break. That's a little bit of an advantage, I think, for the state. I thought it was a very typical Thurman presentation. He was cool hand Luke, even tempered, had good delivery, set out the facts in the Joe Friday manner. Also, I've had some people tweet saying, hey, Long, quit talking when we're trying to watch the trial feed. And to that, I'll tell you, I'll do the best I can. So sometimes we don't actually know when the trial has reconvened, and I may talk over them a little bit, but I will do the best I can. And that's a good pointer. And I appreciate that. That came from Court Chatter. Had another listener said, hey, I'm watching you from Holland and you're doing a great job. So we want to say hello to our Amsterdamians. I don't know if you'd say it that way. When we come back from lunch, we're going to see the opening statement of the defendant. I'm anxious to see that and see what they say about some of these portions of proof that we have been promised that we would see from the state over the course of the trial. I'm really particularly interested in how they address the issue regarding the blue drink. It was my understanding in a pretrial motion that they were ordered to not go into the blue drink as being something that had been potentially spiked with a knockout drug, which was the state's theory in the first trial. He seemed to make a big deal about the blue drink in his opening statement. So I'm wondering if how far the court will permit, and it came in without objection, so I'm wondering how far the court will permit the state to go down that line. Your thoughts?
Well, I've said before, and of course people may be tuning at different times, and I'm certainly not a TV professional, I'm just a citizen here, and I've been on the other end looking in, not sitting here in a seat like this, but it's, I'm pro-victim, and so, and I think it's really in the interest of the victim that everything be done right. Otherwise, you might have a mistrial, and then you end up.
You have to go again,
and you may get tired of going again.
That's another thing too. General Thurman referred to her as victim in his opening statement, and maybe there were some pretrial proceedings in that vein.
Well, it's not like that. It's I just in the first trial when I sat there and watched, I've talked about the heaviness that's in the drama and the theater in that room. And if anyone's never been to a criminal court trial, you maybe got a traffic ticket. When you go to trials like this or whatever, and you get in that room, there's an electricity just being in the room. You call it an oppressiveness. It's a darkness. It's got a feel to it. And when I went, that's the way it was. It hits you as soon as you walk through the door and you sit in the back. Of course, I got banned from the trial and then didn't see it. And that's why I'm sitting with here now, because you were nice to invite me. But when I watched when the Terminator gets up in front of the jury and he's telling them things. And I remember in the first trial he got up and he said that I don't remember who it was, but he said they had urinated on the victim. The moment that I heard that in the first thing, watching on TV, not being in the courtroom, not being there, that it was over.
Yeah, that's a powerful piece of proof. Sure.
You've seen a lot of the evidence and the proof. I watched the trial, so I'm just saying those kind of things, the video, those kind of things. It was almost, if you're a juror, just even hearing that, to suspend belief or whatever to go through the whole trial, I think would be very tough on most people if what they're up there saying is what happened.
Now, my recollection of the proof in the first case was that one of the four guys named in the indictment who testified for the government, in exchange, in the hope that he would get some consideration, testified about the urination ordeal. Let's see if any of the scientific proof bears that out. or whether they're flying just basically on the account of someone who certainly has something to gain or lose from the state being happy with his version of the events, and see how that plays out. That's a powerful piece of proof. That's something that is a home run if you're the state, that if this alleged victim was urinated on by the defendant, that is, or by someone under the defendant's direction, or solicited or aided or attempted to be aided in the accomplishment of that deed, that would not bear well at all for any defendant.
As someone banned, as someone who just had my own bench trial hearing and conviction last Wednesday in Judge Cheryl Blackburn's court, a lot of what I look at and see here feels like smoke and mirrors at times. And the problem is there's a victim from out of state that's in here, and I'm just saying this because we don't have a script or anything. I'm just in there. I don't want anything being done that would jeopardize her getting a fair trial. I don't want somebody doing something. Yeah. I don't want them coming and doing something they don't need. There's a video and there's enough information, I know you've seen it, where you may not have to go do a lot of the stuff that or whatever to get what it is you're wanting if you've really got things that are there.
Right.
And that's all I'm just saying, it sounds, I don't know how it sounds, I'm just talking from my own experience and what I'm seeing going on is, and I don't trust a lot of people anymore. I've got, my thing here says State of Tennessee versus Austin Davis. So and I know you've had.
And just
that
so everybody
thing.
knows, it's not like you've been accused of murder or anything. That's basically a criminal contempt citation as to whether you recorded a proceeding that you were ordered not to.
It's all about.
So I want to put it in its proper context.
It's just about trusting the government. Trusting.
Right. Yeah.
It's about trust in the process. And so there's a victim that's
sometimes you paint yourself to be much more nefarious than you actually are. And I just want everybody to understand
the thing
what
also,
you've been accused of doing is fairly innocuous in the course of things. You can't liken that to Vandenberg's charges, is what I'm saying.
No, I know. I'm just saying when it says that I'm banned from a court for the public safety.
Yeah.
In this day and age, that's a pretty serious thing to put on somebody. And I'm just saying right here now, for people watching, of course, I don't think you're worried. You hadn't frisked me, and I don't think you're worried about.
No, I'm not too concerned. No.
But I'm just saying that people, I'm talking from the other side. You're inside of it. I'm talking from the guys that are sitting out there on the TV, or the women that are watching the show, or whoever, and they're watching the trial. They're going to court chatter. The court chatter is the guy in Netherlands. They're watching. What they want is they want to know that the process is right, that the truth is there, and they don't want to have what happened in Stanford. Or they don't want to have somebody get off because somebody did something they shouldn't do or overreach. What they don't want is they don't want cheating on either side. They don't want cheating.
That's
exactly what I
right.
think.
They want a fair process.
They want a fair process. And so that's what I want. And I want that, and I am passionate about it because I want that because there's a victim sitting there who doesn't get to go up and say anything until finally get the call. And they're trusting all this too. And she needs to have a fair process. She needs to know what happened.
Right.
If she was unconscious, she needs to know really what happened. What did happen?
Right.
Is it made up? Is there something over here that didn't happen because she wasn't apparently conscious when it did? That's all I'm saying. I think that's what trials are for.
Is to ensure that there's a fair process and that justice is reached. We're going to break for lunch. You're getting the long version of the Vandy Rape retrial. When we come back, we're going to have the opening statement of the defense team. We went to break on the opening statement of the state of Tennessee, which was very moving and well presented and impassioned. This broadcast is being brought to you by First Choice Moving and Storage, A Way Out Bail Bonding, and Justin Swallows and his show, Saturday Sports Flash on WJZM. We want to thank all as well, Charter Channel 194 for airing this, as well as the various and sundry video streams that are streaming us. And we want to thank Channel 4 for permitting us to piggyback their feed. You're getting the long version back after lunch.